Good morning and welcome to the District of Columbia Court of Appeals. We have 3 cases on our calendar this morning. The first is 24 CF 242, SHAQUILLE Taylor versus United States.
I'm taking no chances this time. Good morning. May it please the court. Mindy Daniels.
I'm going to interrupt you, Ms. Daniels. Can someone turn off the ringer on their phone, please? All phones should be silenced or off in the courtroom. Thank you. Sorry to interrupt.
Okay. May it please the court. Mindy Daniels for SHAQUILLE Taylor, the appellant, and I'll reserve 3 minutes for rebuttal, please. I'd like to launch right into the issue of the jury re-instruction in this case. And what happened was that the jury was initially instructed in line with the Red Book instruction 4.103 for AAWA, aggravated assault while armed. It was also in accordance, even though the court has never specifically adopted that instruction, in Coussart versus the United States, with the government cites at page 33 of their brief, 143A3rd 27, 2016. The third element of the instruction was challenged, but they set forth the first and second element. And in there, they used the bracketed language to include the name of the injured person. And nothing was said about that. They just said, here are the elements. And the Red Book does include brackets for the name of the injured person, which is what occurred in this case. There were no objections to the initial jury instructions. There wasn't even really any discussion. So number 2 element of that charge was that Mr. Taylor was aware that his conduct created an extreme risk of serious injury to Mr. Gage under circumstances which demonstrated an extreme indifference to human life, and Mr. Taylor engaged in that conduct nonetheless.
Ms. Daniels, can you tell us whether it's your position that that instruction as given, in other words, inserting the name, is the correct understanding of the law, or that once it was given, it should not have been undone, regardless of whether it was the correct understanding of the law?
Yes, the answer to that is yes.
Well, it was an or. So
what my position is that the way the instruction was given was a correct statement of the law. Both the way
Can I ask you a flip side of it, which is, are you saying that the revised instruction was an incorrect statement of the law?
No, I'm not saying that. I'm not saying that it was an incorrect statement of the law. What I'm saying is that it changed things.
But, okay, I'm sorry. It seems there are a couple of ors here, and you've answered yes to both of them on two fronts. So you either insert the name and it has to be a specific party to whom the reckless conduct was directed, or you don't insert the name and you insert human being and it doesn't have to be a specific party to whom the reckless conduct was directed. So which of those two is your view is the correct?
The jury was instructed correctly. And in accordance with
And by correctly, you mean that the jury was correctly instructed that the government had to prove that your client was aware that his conduct created an extreme risk of bodily injury to a specific person, and in this case, to Mr. Gage. It was not enough for the government to show that when your client was driving over 100 miles an hour, around 100 miles an hour,
a little less
than 100 miles an hour on Massachusetts Avenue at 2 o'clock in the morning, that he might have been aware that his conduct was causing a risk of serious bodily injury to anyone in the world. He had to have that disregard of the risk to a specific person. That's your argument?
That's
because that doesn't seem to be what the statute says. And there is a there's a disconnect between the statute and the model instruction.
So my first argument is that the instruction was correct. Okay. My second argument is that if the court is going to see that there's a disconnect there, and perhaps the court wants to say, well, you know,
Well,
the statute.
let's not go to the if yet. Can we just stick first with you're saying that the instruction as given was correct? And I think what my colleagues and I are trying to figure out is, how do you think that the instruction as given, saying that this disregard of the extreme risk of bodily injury had to be specific to an individual identified person, how is that consistent with the statute?
It's consistent with the statute in that, well, the statute says another person. It's very vanilla. Okay. So in this case, the victim in this case was Mr. Gage. Okay. And what's unique about this case and why the instruction lent itself to this case is because, and why the defense said it changed the instruction was, as a factual matter, the government's expert witness, Brian Chase, testified with certainty that he took his foot completely off the gas, the accelerator pedal, and applied the brake before impact with the Jaguar that Mr. Gage was in. Okay.
Right. I mean, I guess.
So it goes
we're
to
skipping
mens rea.
ahead. Excuse me, we're skipping ahead now to sort of, well, even if the instruction is given, the second instruction was not incorrect, it changed things and it prejudiced your client. I guess my difficulty with that argument is that defense counsel's argument to the jury seemed to be what you just mentioned. My client was trying to brake as he went into the intersection and went through the red light. You know, in the last 2 or 3 seconds, he's decelerating from, 95 miles an hour to 91 miles an hour. It seemed like the argument was he wasn't trying to hurt anyone. And so if the defense is he's not trying to hurt anyone, then I'm not sure I understand what the prejudice is to more clearly instruct the jury, consistent with the statute, that the government has to prove that he was aware that his conduct created an extreme risk of bodily injury to anyone.
Well, closing arguments took place after instructions. Okay. And
Right. They got the red book instruction, then they had closings, then they got the re-instruction consistent with the statute.
right. And the government argued first. And when they addressed
But
that,
my point is, sorry to interrupt, that the red book instruction is given that seems to require a mens rea of recklessness with respect to a specific person. Closing argument is given where the defense seems to be arguing not just that your client didn't mean to hurt Mr. Gage, but that he didn't mean to hurt anyone in the world. He was trying not to run the red light. He was trying to decelerate. And then the proper instruction was given that's consistent with the statute. That seems not in tension at all with his argument.
Your Honor, I'm sorry to disagree, but I read the defense closing argument differently. I think he tracked the jury instruction and specific to Mr. Gage. And I'll cite to the transcript 11-2 at 85, 91 to 92, 94 to 96. He argued that the evidence was irrefutable, that as to Mr. Gage, the expert witness said that he braked. The defendant testified that when he saw Mr. Gage's car, that he tried to stop. And also the government, who went before the defense in argument, they specifically stated the second element, 11-2 at 77, that as to Mr. Gage, it was the heart of the case. So I understand that Your Honor is reading the arguments more broadly.
Well, I'm just
And-
looking at page 95 where defense counsel is arguing. And he says to the jury, I'm not going to insult your intelligence, but is he using the vehicle with intent to assault someone? No, he's not. At that moment, his state of mind was, I've got to get out of here because I'm in danger. That's not the intent to harm anyone.
He argued that as well. He broadened it a little bit, but he specifically argued as to Mr. Gage, the expert witness. The expert witness lended its opinion to what actually happened, not what could have happened. So I think that the first instruction goes to what actually happened, who the victim was, and not what could have happened in the broader world
Can I
of
ask you a
things.
procedural question about this argument? So the form of prejudice you're identifying, which is the instructions were given to the jury and the parties gave closings on the basis of those instructions. And then the jury note raises some legal issue that either leads the trial judge to think the instructions should be changed or that the new legal principle should be brought to the attention of the jury to help answer the problem. And then a party will think, well, it would have been good to know that if at the time of original closing, that I could have focused my closing on what the jury is now going to hear the fuller picture of the law is. That's a standard issue that arises if the jury is going to be given new legal ideas, whether different from old ones or supplemental to them. But usually the way that gets handled is that the party who thinks that says to the trial judge, Your Honor, there's a question of how to substantively respond to this note, but there's a process question. And I would like supplemental argument so that I have a chance to address the jury on this new legal piece of information that is either new or different from what was told before. And we have cases about, that as a remedy and how that all spins out. Was there any suggestion made to the trial court when the question of re-instructing the jury came up by defense counsel to raise the concern you're raising now to the trial judge and to ask for supplemental argument and to say, look, this is just not fair. I predicated my argument on a different instruction and now you're pulling the feet out from under me. So either don't do it because it's procedurally unfair, don't change at all, or at a minimum, give me a chance to argue supplementally to the jury to kind of say, okay, now, the judge is giving you some additional legal information. Here's here's what I would like to say now that that's been clarified for you. Was there any suggestion like that to the trial judge?
No, the defense counsel did not. What he kept saying basically was, well, you instructed us to Mr. Gage, and what he said specifically was at 11:3 at 13, he said that the proposed re-instruction would defeat the purpose of the original jury instruction. So,
And do you think- and do you
and to
think
be
that
honest, I think it would have been very
Well, I
awkward.
was about to ask you, do you think that,
I don't think it was practical.
well, you think that if let's say the defense attorney had raised this concern and the judge had said, okay, I understand where you're coming from, but I do think it's important to get the jury the right legal principles. And so I'm going to give the jury, an accurate, again, assuming for a moment that the re-instruction was legally accurate. The trial judge thought it was. I'm going to give the jury the accurate instruction. And I'm going to give both counsel a chance to have supplemental argument. You think that that would have been reversible error because it just couldn't, it was so unfairly prejudicial to kind of shift horses in the middle of that it couldn't have been procedurally fixed. Is that your
Yes, I mean, I think that's why defense counsel didn't.
And why would that be? Because you think the jury wouldn't be able to kind of set aside what was said before? If defense counsel got up and said, I made some arguments that were, predicated on the way the instruction was worded. The judge has changed things a little bit. So I want to, be heard from you again. I want to hear, speak to you again, under the law as it's been more fully explained to you. And here's what I want to say. Why do you think that that wouldn't have been adequate? And it would have been so just impossible for the jury to hear and listen to and fairly assess the new argument?
Well, I wouldn't characterize it as you did as a law more fully explained. I think that,
Well, however you characterize it, why wouldn't supplemental argument? Why do you think supplemental argument would just have been absolutely an inadequate remedy? And do you, are there cases of ours that you would rely on to support the idea that
Well,
someone argument
because
couldn't have worked there?
Because in the first instance, it's specific to Mr. Gage. And that's what defense geared his closing argument with respect to that. And in fact, you know, the uniqueness of this case is that you had a government expert come in and talk about what he did. You know, when he realized the risk, because the instruction, the only thing that changed in the instruction was another person for Mr. Gage. Okay, that was the only thing that changed. And, you know, the instruction itself was, so what's the mens rea, right? The government had to show that he was aware that his conduct created an extreme risk of injury for the first time around to Mr. Gage, right? Under circumstances that demonstrated an extreme indifference to human life. So with respect to Mr. Gage, we know what happened right before impact. I mean, you're right. I mean, he's going however fast, you know, he's going, but let's presume for the moment that, you know, nothing else was in the way. And even though his conduct may have started out as reckless, the indifference to human life and awareness following the instruction, you know, if you switch out any person to Mr. Gage, I think that, well, okay, so why did the question come up to begin with, right? You know, I mean, the jury says, hey, can we swap any person for Mr. Gage? That indicates to me at least that they were stuck on, you know, what the defense was.
Well, they probably were because the instruction, I think, was erroneous and inconsistent with the statute, which I don't know on the record here, but presumably they, well, I don't know if they had it in front of them, but it also doesn't make sense, right? So maybe that's what prompted the question. And then piggybacking on Judge Easterly's question, I mean, wouldn't the closing argument of defense counsel have been 2 sentences on this count at least, which was, it said I had to know that it was Mr. Gage. I was 100 yards away. No way I could have known it was Mr. Gage. Never seen the guy before in my life. Have no idea who he is. I now sit down. I mean, why wouldn't that have been the closing argument?
Well, that wouldn't have been very helpful.
Well, I think it would have been extremely helpful under this erroneous instruction. That would have been my closing argument under this erroneous instruction.
But
If defense counsel was truly relying on this misstatement of the law.
well, the instruction itself in the red book where you plug in the name, at least, those are in brackets. Okay.
Right.
So let's just assume for the moment that it's not erroneous, but optional. I mean, that instruction has never been held to be erroneous. In Coussart, they dealt with the third element. They repeated what the instruction was. They didn't talk about it being erroneous. So that instruction has never been held to be erroneous. So the point here is that they use the option.
Would you agree that it's got to be wrong? Leave aside the statutory language, but just a matter of common sense. If the evidence is that the defendant, I don't know, set off a bomb in an area where there are lots of people wandering by and ended up injuring one of the people, but you had never met that person before, had no interest in that person, didn't know that person existed, and would set the bomb off remotely, so I had no idea that there was any person there. And you know, if the instruction was that the defendant had to have been aware that his conduct created a grave risk of serious bodily injury to name the victim, do you really think that it should be or is under the statutory language or under a reasonable interpretation of the statute of defense that the defendant would say, well, I mean, I had never met this person before. I had no awareness I was endangering that person. I certainly had awareness that I might have been endangering somebody who would happen to be wandering by, but I had certainly, if the requirement is that I had some reason to be aware I was going to hurt that particular person, I had zero awareness of that. Should that be a defense under the statutory language or under a reasonable interpretation of the statute?
Well, you know, the trial court dealt with that to a certain extent. It talked about the mens rea and likened it even to second-degree murder. You know, the court said, well, that's like, you know, if I start a fire outside of a club, does that mean that I have to name, you know, every victim? You know, is it still AAWA? And, you know, and the court actually said that mens rea can be
You're talking now about what the
inferred.
trial court said here, or are you talking about what? this
No, the
court
trial
in
court
some-
said here.
I just want to make sure.
Here,
I understood what
when
you
they were
saying.
discussing
Right.
the instruction itself, you know, the court was opining, well, you know, let's talk about mens rea for a minute. You know, it's sort of like second-degree murder. And, you know, do we really need the name of the person? You know, the defense is saying, well, yeah, we do, because they were instructed that way first. But the court also said that mens rea can be inferred from the actions. So we have the action of him speeding.
Well, just back to
Okay.
my
That-
hypothetical, you know, because I'm
And
trying to get
then-
an answer to a legal question, and your answer seems more thematic on the trial court said some things that relate to the topic. But what, in the hypothetical I gave, do you think that it should be a defense if the jury believes the defendant, when the defendant, let's say, testifies and says, I never met this person before, I had no intent relative to this person, I had no awareness of any risk to this particular person? Should that be a defense? You know, is it a defense under the statute properly understood? That's, and I haven't gotten an answer to that question yet, so I'm hoping I will.
Well, if the jury was instructed that
I'm
way,
just asking if
that
the
might
jury
be
should
the only
properly-
defense.
I'm asking if the jury should properly be instructed that way. If
No,
that's a correct interpretation.
I would
of the
answer
statute.
that might be the only defense. That might be the only thing that they would be able to argue. I mean, if it's directed at any person, you know, then
I'm
you
still a little
can,
unclear. Is your answer to my question, yes, that should be a defense?
I'm sorry. That, could it be a defense?
Should it, is it correct interpretation of the law that that is a defense?
Well, it can be argued as a defense. I mean, whether it would be
I
allowable
mean,
under the
almost
law.
anything can be argued as almost
Yes,
anything. So
yes,
that,
yes. The answer would be yes then.
you think it is a correct interpretation of statute that would be a defense?
If the jury was instructed that way, yes. I think that argument would be
I
a
don't-
correct interpretation.
That
Daniel.
seems circular because
I'm sorry.
I'm asking whether the jury should be instructed that way if the instructions are a correct interpretation of the statute.
Whether the jury should be instructed as to any person?
No, whether the jury should be instructed, the defendant has to be proven beyond a reasonable doubt to have acted with a, you know, conscious disregard of a known and substantial risk, if that's at least a rough paraphrase of the requirements, with respect to the particular victim in this case. Is that a correct way of instructing the jury under the statute? Is that lawful or is that unduly restricted?
I think it is lawful. I can't say that if the jury was instructed as to another person, that is inconsistent with the statute. The way the instruction is written, it has the
See,
brackets.
and that's where I find it seems like there's a yes or no answer to this question.
I-
Either it's correct to tell the jury the defendant has to be shown to have this mental state with respect to the particular victim. And that's the right way of interpreting the statute. Or it's correct to say, no, the statute is not so narrow. In fact, it's sufficient if the defendant is shown to have had that mental state with respect to any person. The statute means one of those two things, not both, or not like discretionarily either. And so let's just assume for a moment, humor me, that the statute means only one of them. Do you have a view about which one would be correct? And if you think the correct answer is that it should be told, the jury should be told that the mental state has to exist with respect to the particular charged victim. But what's your argument why that should be so? I know you said two things, which is the Red Book instruction is consistent with that, and in cases not where the issue wasn't in the dispute, that language kind of appears. So you said those two things, but is there anything else that you would say in support of that?
Again, because I think that, I mean, you're saying it has to be either or. I mean, you're confronting me with it. It has to be one or the other.
That's what seems to me. Now, if you want to argue that it could be either, I'd be
No,
interested in that theory too, but.
No, but that is my argument, that it could be either. In this case, we had evidence of, if you want to characterize it as mitigation.
But it's not about what the evidence was. Why do you think that it could be legally correct to limit the jury to saying that the government didn't prove the mens rea as to a specific person?
I'm sorry, can you repeat that specifically?
Two choices. Either the statute says you have to be reckless. So that's going to be my catch-all word for the many words that are part of the mens rea element of this crime. You have to be reckless as to a specific known person, or you can be reckless as to anyone. You don't have to know them. You don't have to know they exist. It just happens that they come on the scene when you are doing the act recklessly. You're saying that the statute can be interpreted both ways. It seems like that is not possible, right? Because to choose the first way and say that you are reckless as to a specific person, right, to require the government to prove that means that it's not enough for the government to prove that you're reckless to any person. So it's exclusive.
Well, I'm going with the way the Red Book.
So you're going to endorse the
interpreted
Red Book. Okay.
the
I
statute.
think we've got your argument on that, and I'm going to let you sit down because you're well over time.
Okay.
And we'll let you have some
Can I
time
just
on
one sentence,
rebuttal.
add one sentence?
Yes.
I think that it also matters where, like in this case, the person is known as opposed to other cases where the
I'm going to
person
let you
is not.
talk about that on rebuttal and tell us why that matters as a statutory matter and not as an evidentiary matter, if you care to
Okay.
do so.
Thank you.
Okay. Thank you. Don't forget your, yeah.
Good morning, Your Honors, and may it please the court, Chimnamso Kalu on behalf of Appellee, the United States. The government is asking the court in this case to affirm the trial court's ruling. And I'll focus on the aggravated assault statute, since that's where my friend on the other side focused her argument as well. Your questions seem to be focused on whether the original instruction versus the re-instruction, which one was legally correct. Our position is that the re-instruction was legally correct. As we set out in our brief, the re-instruction followed the language of the statute. And we cited also this court.
Do you think that this court needs to issue an opinion saying that the Red Book instruction is wrong?
I think that would be.
Is this a recurrent problem in the government's view?
I, standing here, cannot answer that question. What I can say is that in reviewing this court's law to address this argument, I didn't find another case where this sort of confusion arose with respect to this statute. And I think that makes sense, given that this court has held for a long time that recklessness does not require conduct to be directed at a specific person. And the court has also clarified that the A2 aggravated assault, as we referred to it in our brief, that the standard there is gross recklessness. So I think it may be helpful, but is it necessary based on a correct understanding of the law? Perhaps not. And Judge McLeese, you had asked whether the prejudice, I'm sorry, whether you had asked about supplemental argument as a remedy. I think that would have been an appropriate remedy had it been requested.
I'm sorry, I didn't hear you. You said it would have been Inappropriate or an inappropriate?
And appropriate. I
Thank you.
apologize, allergies. But the fact of the matter is twofold. First, the argument in this case about the aggravated assault, that it was an accident, that seems to have been the argument that would have been presented had the correct instruction been given in the first place. And I cannot conceive of what a different argument would have been with the reinstruction. Even if there were some other argument though, there was no request for the court to allow supplemental argument after that instruction, the reinstruction was given, or the clarification, I'll really call it, was given. And I think that it didn't make sense. The original instruction didn't make sense as it was given, because the evidence was that Mr. Taylor did not know Mr. Gage, but rather that Mr. Taylor was using the Nissan in such a manner that it was beyond it was inconceivable that somebody would not know that they had created an extreme risk of serious bodily injury to anybody who had been on the road at the time.
Can I just ask, I mean, maybe there's no great answer to this question, but if it's obvious to you and maybe others that the original instruction was wrong and made no sense logically, it's the government's position now that it's wrong and that the reinstruction was right. Why didn't anyone say anything, I guess is my question at the time. I mean, obviously, if they had, maybe we wouldn't be here, and then maybe that's your answer. But whether we say something in an opinion that the Red Book instruction here is wrong, or whether the government now understands that going forward in the trial court, it, should clarify this during the jury conference. I mean, the instruction conference, I don't know, but I don't know if you have an answer to my question.
I think two answers. First, as perhaps, as you said, if this had been caught at the time, maybe we wouldn't be here. Perhaps there are examples of cases where the instruction was given as the reinstruction was, that's the original instruction. But even so, well, I mean, I guess I'm really not sure how it's, I guess the other thing I could think of, Your Honor, is that there are cases where putting a specific person's name in place of another person is a narrowing of another person, right? So you could conceive of a situation where a person engaged in grossly reckless conduct and did know that a specific person was going to potentially be injured. And so perhaps the instruction in those cases, while doesn't track the statutory language, wouldn't necessarily be inappropriate and certainly wouldn't be confusing to the jury. But as I think Judge Easterly pointed out, or intimated with a question, we shouldn't be focused on facts, but rather what does the law require? Like that we shouldn't, the instruction should not depend on the facts, but rather should be the instruction that applies in all circumstances. And if the court has no further questions, and I know we did not talk about the other issue in the case. If the court has no questions about that, I also, I would direct the court to the arguments in our brief. And thank you. We ask that you affirm.
Thank you.
I want to go to the statute, aggravated assault, and I want to read it into the record. A person commits the offense of aggravated assault if by any means that person knowingly or purposely causes serious bodily injury to another person. So, the first element, said to Mr. Gage that, they had to find that there was an injury to Mr. Gage. But the statute goes on to say, well, there's also whether there was an intent to injure. The parties decided, there wasn't a specific intent here. But the statute goes on to say, under circumstances manifesting extreme indifference to human life, that person intentionally or knowingly engages in conduct which creates a grave risk of serious bodily injury to another person and thereby causes the serious bodily injury. So if we do it the way the government wants to do it, and seemingly the way the court would be satisfied, then in this particular case, under the unique circumstances of this case, because this is what we're dealing with, we're not dealing with was the issue at first in a the initial jury instruction, can we or can't we, or should we or shouldn't we put in Mr. Gage? They did, and there was no objection to that. So that's how the jury was instructed. So I think that the issue here is upon re-instruction, did that, even if it goes with the statute, did it prejudice him because it changed the instruction? If you do it and you say, no, it didn't matter, let's just go along with the statute, any person would have been okay. I think that then, the argument would be, well, then we're only focusing on how fast he was going before the danger actually presented itself. And I mean, what I'm hearing would happen if you say, well, it can always be just any person, and that the instruction is just completely wrong, as the Red Book bracketed language says, and it shouldn't have been followed that way, then you're only focusing on the initial actions. And there can be no mitigation then
I guess
when the actual danger presented itself on the extreme indifference to human life.
Ms.
So
Daniels.
if you start out with extreme indifference, that it can't be changed. There's no mitigation as we go along.
I guess I'm not understanding. I mean, I don't, first of all, it's not this court's preference. We interpret laws as written by the legislature. The legislature used the words another person in the statute. So we're trying to figure out, what does that mean? And another person seems broad and not specific, intentionally not specific to an individual, a known individual, a named individual. And so I guess, I mean, I hear your argument about where the jury is focused on and on your client's specific acts of speeding. It still seems to me, and I'd like to hear you explain to me why they could not, that the jury could still determine whether or not your client is engaging in conduct which creates a grave risk, right, to anyone when he is decelerating, right? And it's up to the jury to decide, well, he's decelerating in the 2 seconds before he makes impact with another car and runs a red light, or he's decelerating 5 blocks before, right? The evidence in this case is that he's, coming out of a tunnel on Mass Avenue at 2 o'clock in the morning, going 95 miles an hour, and in the last, less than a block is decelerating. It's up to the jury to decide whether that is conduct which creates a grave risk of serious bodily injury. And I'm not sure, and you can, again, explain it to me, what the identity of the person has to do with that. I don't see how the identity question limits the jury's consideration of the question that you are raising. Because
What the statute says is that there's the word aware, okay, in the jury instruction. So it's by any means that person knowingly or purposely causes the injury under circumstances manifesting extreme indifference to human life.
And the key word there is cause relative to the point you're making now, because it seems as though it doesn't really focus the applying the statutory language of allowing the mental state to extend to any other person doesn't necessarily focus on the actions that are before any particular time, because the issue that the jury has to determine is whether the the conduct that was reckless in that way caused the injury that ensued. And so if to follow up a little bit on something Judge Easterly was suggesting, the evidence here had been that your client originally was going 94 miles an hour, inferentially fleeing from the police perhaps. But then he'd slowed down because it seemed like he was away from the police and he was driving at a more reasonable speed. And then he, came to a red light and he ended up running the red light and having this collision. And the question was, he did some reckless stuff before. I mean, driving 95 miles an hour and on streets like Massachusetts Avenue is pretty reckless in the normal sense of the term. But that might not have caused the injury that later ensued. He was, at the time of he ran the red light, he seemed like he'd slowed down. And so the focus is, because of the word cause in there, it seems like the focus, even if the risk can be to any person, is going to be about the relationship between the conduct and the injury to the person, which means that you're not always pushed way to the beginning of this encounter. And if the facts had been different, a jury might well have been able to think, well, yeah, there was some recklessness at some point that caused lots of risk to lots of people. But the injury that was caused to this particular person was not caused by reckless conduct, because that conduct was way before and it didn't cause what happened here. What happened here was maybe he was not paying 100% attention at a red light, but that can happen to anybody and that might not be criminally reckless. So I'm not quite sure I follow your argument about how applying the statutory language sort of unfairly shifts the focus to way early in the circumstances here or generally.
Well, what Your Honor was saying was right about, where's the focus, right? And in the initial instruction, the focus was Mr. Gage. So we're focusing on impact with Mr. Gage. And that's where the defense came in and said, well, with regard to that, we know from the expert, we know this, we know that, we know the other thing. And trying to get him out from, under the charge in that way. And that's what he was focusing on, was an extreme indifference to human life, Mr. Gage. And the second instruction was an extreme indifference to human life in general. So, could the jury have been instructed, the other way, a discussion about that, whether it was right, whether it was wrong? That's not what occurred. There was no discussion about it at all. Everyone agreed that the instruction was fine. So there was nothing brought up about, oh, it doesn't make sense, it's not this, it's not that. So at least when we started out, it all made sense. So so I'm going to go back to the issue is, in this case, when they were already instructed whether it was right, whether it was wrong, did the re-instruction change the original instruction and did it prejudice the defense? And our position is that it did, and especially because when closing arguments and the instructions happened. So, one after the other. I also want to point out with the, I realize I'm out of time, that with the second issue, I just want to make a correction on something in my brief, that at page 23 and 27 in the brief for appellant, the suppression hearing is cited as a date of 10/31, and that's a mistake. It should be 10/30.
Thank you.
All right, thank you.
Thank you for your argument. Thank you, counsel. The case will be submitted. The second case on our calendar today is 24 AA 720, Deirdre Brown versus DC Board of Elections.
May it please the court. My name is Deirdre Brown, the petitioner in this case. I would like to reserve 3 minutes for rebuttal at the end. This case is not about whether you agree with ranked choice voting or not. It is about whether the Board of Elections followed a lawful, fair, and transparent process to certify Initiative 83 for ballot access. Thousands of petition signatures, as we know, thousands of petition signatures were discarded. Exactly 4,802, according to the Board of Election, due to whiteout, but others were kept in, and we still do not know how many of those exist.
So Ms. Brown, you filed your own petition challenging the signatures. And you identified a number of pages of signatures that you thought were suspect.
Yes.
And I think it was 710 pages of signatures, if I'm correct, or at least that's what the registrar said it was. And the registrar calculated and said, look, even if we discount all of the signatures that you were challenging, they still have enough signatures to meet the statutory requirements to let this initiative survive.
So my petition challenge included 710 that were challenged not about whiteout, about other issues.
Well,
And the
let me just
yeah.
make sure I understand the facts, because I
Yep.
thought that the cover sheet to your petition identified whiteout as a reason.
Yes,
Yes.
Right, so then the
one of
710
several reasons.
right. The
correct.
710 were for other issues, but I
But
said in there,
That
please.
seems not right. I'm just looking at like page 1 of like
Yeah.
the pages, and it's one of the pages that was attached to the 700 whatever. And the first one, it shows 5 lines.
Yes.
And the only line that has writing on it is line 3, and it names a voter and gives an address, and then it gives in a box that says list board regulations provide an explanation of the petition defect. It says whiteout used on address. So it seems like the attached pages, and there are lots of them that were attached.
Right,
The only complaint that is specified on the page as the reason for the challenge to the signature at issue was whiteout.
right. So on the cover sheet, I asked the Board of Elections to please go back and discard any signature line that had whiteout because that's fraudulent. I also asked them to throw out any pages that
I
had
know that, but
whiteout.
I thought you had answered Judge Easterly by saying the 700 pages were not about whiteout. And it
What-
seems to me like the 700
I'm
pages
sorry, yes,
were
the
about
700 pages were about whiteout, yes.
Among
However,
other reasons.
among other reasons.
Okay.
I was trying to say.
And
yeah.
in your petition, am I correct? Aren't you required to identify the specific defective signatures? I mean, I just heard you say in response to Judge McLeese that you identified some specific suspect signatures, but you also were asking the board more generally to look askance at any whiteouted signatures. But it seems to me under the statute and under the regs, it's your obligation to say, no, it's signature 56, 103, 213, and so on down the list that are problematic and should be struck.
Right, so in the regulations, it also says, at the very last sentence, it says, a challenge on grounds other than the alleged invalidity of any petition signature should be properly filed if it concisely sets forth a procedural or other defect. And in this case, I was arguing that, and that's why on the cover page, I said, every signature
I'm
that had
sorry,
whiteout,
you cut off.
I'm sorry, every signature that had a whiteout, yes.
But do you know how, I mean, what is your maximum or total universe? Did you ever set forth the total universe of all whited out signatures that you thought should be discounted?
Well, in my brief, I do set out that I think it's an additional, at least additional 10,000. We don't know exactly. We only had scanned copies, so it's difficult to identify the whiteout via scan.
But you had access to the hard copies, right?
They're saying we did, but we did not. And actually, when I was a petition watcher, I was told explicitly we could not have access to the originals. We were not to touch them. We were not to in any way interact with them at all, that we had to use the scans.
But does the 10,000 overlap? Because the board had already eliminated or discounted a good number of signatures that involved whiteout. Does your 10,000 number include that, or are you saying it's 10,000 on top of what the board had
I believe it's
discounted?
10,000 on top. And then the reason I'm saying that is that, yes, they threw out the 4,802. They do say in their memorandum that they included more by holding pages up to the light to see if there was some kind of voter intent.
Right, but your specific petition with the various pages address some of those, right? Those, you were challenging, to the extent the board looked at some pages and signature lines that had some whiteout, you had gone through, I guess, at least as best you can, what you had available to you and identified, well, there's whiteout on this, and I think all whiteout, any signature that has any whiteout relating directly to it should be out. So that was already alleged specifically in your challenge to the petition, right? But your theory about how to get 10,000 more, I just want to make sure I understand where it's coming from. Is that on the theory that not only should, I mean, your petition challenge reflects the idea, I guess, I think one could say adequately concretely, reflects your theory that not only should like signature 3 on a page that has 5 signatures that had some whiteout, not only should signature 3 be out, but you, I think, were alleging in your cover the whole page should be gone. If there's whiteout on the page, just jettison the whole page. So that, I think, myself, I tend to think was adequately concretely alleged in the combination of you attaching all those pages and saying in the intro, you know, I think with some clarity, I guess, maybe that you wanted all those signatures jettisoned. And the registrar kind of took it that way and said at most it would be 3,500-ish. You're getting the bigger numbers by referring to, I guess it is the idea, as you put it in the kind of cover sheet to your petition challenge, that any page that had whiteout used on the circulator's affidavit should be rejected. That is at least specifically said there. Now, you don't necessarily provide, did you provide every page in your 700 where you were able to identify that was true or no?
No.
Okay.
Yeah.
And then your theory in this court has been also that any petition that was, any signature that was obtained by a circulator who at any time used whiteout with respect to any signature should be discarded. And that's, I think, where you're getting these bigger numbers. Is that right?
Correct. And that's based off of Williams.
And was that, where is that? I mean, obviously you didn't attach sheets that reflect the consequences of that. And the registrar thought that was a defect in your challenge. But just in terms of even of your cover sheet, where's that idea reflected? Is that, I just didn't see any very clear indication that that was part of your original challenge. Can you
Yes,
tell me
so
where
the-
the cover sheet that idea is reflected?
Yeah, so number 1 on there was petition pages with whiteout used on the petitioner's address should be rejected. Number 2 was petition pages with whiteout used.
Could you tell me which, I have them all right in front of me. Which one of these do you think relates to the idea that any page that was?
Yes.
Any page that had signatures collected by a circulator who had ever used whiteout on any of the pages should be jettisoned?
It was number 2 and 3. Number 2 was rejecting the pages, and number 3
What?
was the sentence
Can you
rejecting.
explain why those reflect that idea? Because the second says a page with whiteout used on the petitioner's printed name. That doesn't reflect the idea that not only that, but if it is a page that was prepared by a circulator.
But that was
whiteout
number
on the
3
page.
is the circulator one.
Right, so
Yeah,
3
so
says
yeah.
pages with whiteout used on the circulator's affidavit. So that would only be any page wherever, I don't know where the circulator affidavit is that the line?
Yes,
down
at the bottom,
Right.
yes.
So that would just be any page where there was whiteout on the affidavit itself.
Yes.
Not any page that was prepared by a circulator who on some other pages had ever used whiteout.
Right, so,
So I just didn't see that idea, that theory floated anywhere in your.
right, so what I argued was that, what I was asking was 3 things. 1 was any signature that had a whiteout should be tossed. any page that had a signature whiteout under Williams should also be tossed. And if there was any tampering in the circulator's affidavit, that page as well should be tossed.
Right, but where is the part that says, and also any page prepared by a circulator who had somewhere a page that had whiteout on it? I haven't found that yet.
Well, it would be either whiteout was in the signature part or the whiteout was in the circulator's
No,
affidavit.
no,
This is
but
what
if
we
there's-
were
no, no,
finding.
if there's like, let's say circulator's
Right.
name is John Smith.
Right,
And there's a page where John Smith has some whiteout either on a signature line
yes,
or in the affidavit on that page.
yes.
You did in your challenge allege that that whole page should be disregarded. But I still don't see where in your challenge, you articulated the idea that let's go to some other page prepared by John Smith. It's got no whiteout on it. It's got no whiteout on, on an address, on a name, or on the affidavit. But you're saying now the board ought to have disregarded, or the registrar/board should have disregarded any petition, any page that was prepared by such a circulator.
Yeah, that's.
And that's just not in 1, 2, or 3 yet,
Yeah,
that I see.
and you're right, that's not articulated there. It was once I got into the brief and found the case law, right? So,
But
you know.
so when the
yeah.
board, so the registrar gets your petition
Mhm.
and or your challenge to the petition, and it looks at it and says, and gives you a written explanation that says, we've looked at it and under our regs, you would need to have done things you didn't do. The numbers aren't high enough. Did you respond to the registrar of the board by saying, that's not correct? Actually, I have complied with the regulation and here's why. Was that a point that got made in your email correspondence with the registrar or at the hearing that you attended where the board, announced its approval and then had some public comment? Did you make that point ever?
Yes, so in email correspondence, I actually specifically asked that I be given an opportunity to have a hearing, that they have emergency hearing to look at the whiteout issue.
Did you
Because-
understand that you're referring to the email on July 18th, right?
No, I think that email is the one, was that the administrative order, when I asked for
Well,
administrative order?
you had emailed the Board of Elections on the 18th, noting that the Washington City paper was reporting the use of whiteout by proponents of the initiative. And you say, quote, "The crucial questions now are who used whiteout and for what purposes?"
So, no, I'm not sure if I don't have that email in front of me, but I did request in writing an emergency hearing. I'm not sure if that is
You
it in there.
requested, you
Yeah.
then requested an
Okay.
emergency hearing and a ruling on the use of whiteout. And I guess one procedural question I have is, by that email, were you seeking reconsideration of the denial of your request on July 15th? Or were you treating this sort of as a new matter that you were raising and then
Mhm.
continued to pursue in front of the board? And if so, sort of what was your procedural foundation for being able to seek relief anew via email? It's just not clear to me sort of where you were, where you had any sort of procedural foundation for what you were asking for on the 18th.
Right, so at that point, as the petition watcher, I had spent a lot of time talking to general counsel as well as the register of voters and the executive director, pointing out that this is what's happening. I did do the challenge, it was denied, but we were seeing more and more of the whiteout as we're going through this 30-day process.
Right, and I
And so-
understand what happened,
so-
and my question is
Yes.
really, first, did you understand that email to be in the nature of a motion for reconsideration of the denial on the 15th?
Yes,
You did?
yes.
Okay. And so
Because-
that was your procedural foundation?
Right, because at that point, we were seeing, like I said, when I first did the challenge,
But
it was before we really knew how many pages, almost every page has whiteout on it.
Here's
And so
what I
now I'm like,
understand
please go back and look.
Sorry, I don't understand your answer, I
Yeah.
guess, because the petition challenge was denied by the registrar on the ground that you didn't comply with the reg attaching sheets and various things.
Right,
And so a motion to reconsider it, either directed to the registrar, like registrar rethink, or another way of looking at it is a request that the board review the determination of the registrar and say, the registrar thinks my challenge is not good, but it isn't, and I want the board to determine it's not good. It seems like that what would have been the substance of that would have been, here's what my challenge looked like. Here was the reasoning of the registrar in refusing to treat it as a valid challenge, but that's not right. And here's why. And actually, I now realize that I would more broadly want to disqualify any signature from any circulator who ever had whiteout on anything the circulator did. And so actually, at least as amended or as supplemented by this thought, really it's an adequate challenge. And so it should be submitted. And then we should go ahead with the process that the regulations and statutes contemplate with respect to a properly filed challenge. That's what that's what I would have thought the substance would have been of a request to reconsider. But none of that is really in the request. The request is a lot, it isn't about that. And I don't think it necessarily refers to the denial of the registrar's reasoning or decision. And it's sort of more, board, I'm bringing to your attention, I'd like to bring to the attention of board a problem, and I'd like to have the board have a hearing on it.
Right.
Which seems more like a separate track than it does an effort to continue to persuade the registrar or the board that your petition challenge was actually proper under the statute and regulations.
Okay.
Am I missing something when I
So,
when I
yeah,
have that concern?
so I understand what you're saying in hindsight, right? But the Board of Elections rules aren't very clear. So there is nothing in the regs that say, how do you reconsider when other than come to the court, how do you ask for reconsideration? So I was advised, bring it to the board, ask them to look at this whiteout issue, because that was the issue. And so that's what I did. Now, if it wasn't phrased exactly how maybe you thought it should have been phrased, okay.
You were
But I'm
advised,
still
you were
asking-
advised by whom?
I had asked a legal counsel, some attorney, and asked them what they thought I should do because
Out,
this
not
situation.
by the board, you're
no,
saying?
no.
Okay.
Definitely not by the board. And so that's why I was told that the actual board, the panel, take a look at it and see if in fact we should be moving forward. Because right at that point, we still had not been certified and it had not gone to data collection. And that was my point. I'm like, we got to take a look at this before it goes to data collection.
Okay, can I ask you to follow up on Judge Easterly's questions about how you understood your request for emergency hearing by the board? How do you understand this petition for review? Do you think you are challenging the determination of the registrar that your challenge to the petition was inadequate under the statute and regulations?
No,
You're not challenging that. You think you're challenging the board's, because if you were thinking of what you did by requesting an emergency hearing as an effort to reconsider that, then the denial of the board of that and your challenge of it here would sort of more again be on this track of there was a challenge to a petition, it was rejected as inadequate. You were trying to get that changed. They didn't change it, so they didn't consider your challenge. They instead treated it as not properly filed. And then in this court, you would want us to say, no, that's not right. Actually, it was properly filed and it should have been considered, and go back and then do the procedures that would be followed if there had been a properly filed challenge. You're not thinking of your petition for
No.
review as that. You're thinking of it more as whatever happened about all that, there came a time when you said to the board, there's a problem. Before you certify, if that's the right term, that may not be the exact statutory term, but before you sign off on the adequacy of the signatures to support the petition and move on to the next stage, I would like you to have a hearing where you address that. And the board didn't do that. And you're challenging the board's failure to do that and its decision to certify without having done that, or approve without having done that. Is that the way?
no, actually, we even moved further from that. So they ignored the emergency hearing. They never responded to me. They then went on and certified the petitions. I did speak at the hearing, once again, letting them know that I thought it wasn't proper. And what I'm asking this court to do is, normally you would be reviewing an administrative order, which of course they never issued. So I'm asking you to, one, have them issue an administrative orders telling us which ones you let in, which ones you didn't, what's the real count, because we don't have a real count. And I'm also asking you to order them to throw out any signature lines were white out and any pages that had white out on it.
Your opponent argues that if what you're doing is seeking review of not through the challenge process, if you're not arguing, look, I had this challenge and that's the process that we're still in.
Right.
If you're instead away from that challenge and you just raised an issue with the board by way of requesting an emergency hearing that was not granted, and then speaking at the hearing, although after the board had voted to approve and move the matter along to the next stage by putting it on a ballot. If that's what you are doing, their argument is there aren't any statutes that allow you to bring those issues to, give you a right to demand relief from the board in that way, or entitle you to review in this court or in their view, any court, if the board doesn't choose to respond to your comment, your request for an emergency hearing or your concerns that you raised. They're just saying that's not the only game in town. Their argument is through this challenge process. And if you're not viewing yourself as still doing that, then there's just no avenue of relief for you. Do you, that's a pretty technical argument, obviously, but do you have a
Yeah,
reaction to
I
that?
argue that this court does have jurisdiction to review administrative reviews of or decisions that have been made by the government agency.
Well, we do under the APA, right? But our jurisdiction under the Administrative Procedures Act is for contested cases. And it's hard for sort of the reasons that you're pointing out that you're dissatisfied with the board's decision to see it as a contested case. Generally, a contested case is where evidence is taken and a decision is made, and there are all sorts of badges of due process that occur, right? And so in this situation, it seems like maybe you could go sue in Superior Court of General Jurisdiction and say, hey, what the board is doing is totally lawless and they're accepting, signatures that have been whited out and altered. But I'm trying to understand sort of what the procedural avenue, if I understood your answers to Judge McLeese's questions correctly, and you do not see this as a continuation of your initial petition, that you clearly have a right under the DCMR to bring. If it's not a continuation of your petition and it's some separate challenge to the board's disregard for your email on 7/18, the board's conduct during its hearing on August 2nd, then I'm not understanding what the procedural path is directly to this court.
The procedural path would have been if they had issued administrative order. And so in lieu of the administrative order, I'm asking you to review their decision because we don't have an order to review. They refused to issue one.
Right, but the concern that Judge Easter is raising is when an agency acts in a way that somebody doesn't like and have standing to challenge, sometimes the aggrieved person, the person who doesn't like that, can come to our court directly. Sometimes instead you have to go to the DC Superior Court, the trial court first, and then if you don't like what the Superior Court did, you can come to us. And the dividing line between which way you go, unless a statute expressly says otherwise, is this idea of whether something is a contested case, which is a technical concept that has to do with whether you have a right to a trial type hearing, either by the Constitution or a statute or regulation. And with respect to this sort of separate track of saying, board, I'd like an emergency hearing because there's a problem and you should look into it. And board, you're having a public hearing where you've just announced that you're going to approve things, but I have these concerns. There don't seem to be regulations or statutes that allow someone who has that kind of a concern to have a right to have a trial type hearing. There is a right to have a trial type hearing, it seems, back on this challenge track, if you properly have submitted one. But on the sort of separate track, if that's what you're looking at it as, it seems as though if there is a place to go, if you don't like what the board did, it would be in the Superior Court rather than here. The Board of Elections argues there's no place to go and I have questions for them about that, but that's the concern that these questions are, is it may be that if you're thinking of this as a challenge to the way the board handled your emergency complaint, emergency hearing request, separate and apart from your original challenge to the petition, that it may be that you've ended up in the wrong court. That's the concern because of these various technical rules about when you have to go where. So that's the concern.
Right. So to answer that, I'm not just a concerned person. Like besides being a voter, I'm also the chair of Vote No Initiative 83. Right? I was also a petition watcher, certified petition watcher during this process. When they issued this order, it aggrieved me, not just as a concerned person. And so I've come to, well, they didn't issue the order, when they verbally issued the order, and when they denied having the access to have an administrative order where they could lay out their factual findings and conclusions of law, that also aggrieved me. And so I interpreted your rules of the court. I don't have the rule number in front of me, but the rule of the court about how you can bring directly here, not having to go to Superior Court first, and review of administrative order or review of a decision by agency, that I could come here first. That didn't have to go through that process.
So, I think we're gonna let you sit down now. You're over your time. I mean, your comments go more to standing. And thus far, we haven't really had any questions about your standing. We might after we hear from the board, but we'll let you talk about that when you get back up for a rebuttal.
Okay, thank you.
Thank you.
Good morning, Your Honors. I'm Christine Pembroke on behalf of the Board of Election, and with me here is our General Counsel, Terry Stroud. To Your Honor's point with regard to standing, it's clear that Brown is not satisfied the requirement of standing. While she asserts her ability to be present during the board's review of the petition signatures somehow confers on her a direct and personal stake in this matter, she is not pursuing any claims of injury pertinent to her status as a petition verification observer.
So I think I'm not quite understanding. So you think that if she were following the petition process, that clearly she would have standing in that procedural vehicle?
If she had qualified as a challenger and filed a valid challenge, she would have standing.
Which I don't
absolutely
understand there to be any debate that she did.
Right.
Right, okay. Do you disagree that, if we were to look at the board's processes and say, this doesn't look like a contested case, would you agree that she would have standing to go over to Superior Court and sue and say that they're not complying with their rules, they're authenticating or verifying, false signatures,
So I don't want to speculate about all of the arguments she might make.
I mean, I guess my point is, it seems like your standing argument is really much more wrapped up in what procedural vehicle she's entitled to use.
I think that's one way of
what
looking
procedural
at it.
path. It's not really a standing question, because she could be aggrieved. It's just you're arguing that she is not pursuing her grievance in the right way.
Well, I don't know that I would want to say that she is aggrieved.
Well,
theoretically,
for the purposes of standing, that doesn't concede any fault or wrongdoing by the board, but right, at the standing stage, we're going to look at the facts in the light most favorable to the petitioner or the plaintiff, right? So if she is arguing that the board is verifying, certifying, accepting signatures that they should not, that would seem to give her standing of a sort in some forum, no?
it's this, it does not give her standing because that grievance is the same grievance that's shared by the population at large.
But
It's
then
not
who
particular to her.
would have standing? I mean, why would anyone have standing? I mean, if they filed a proper claim, a valid claim, then perhaps they would have some sort of statutory standing, but your argument seems to be based on Article 3 constitutional standing, putting aside whether we're bound by that, but let's assume we adhere to it. your argument seems to be that she doesn't have a particular concrete injury because she's approaching this court as a generalized, general voter. So who would have standing, even if they filed a proper petition, who would have that type of standing?
In specific types of initiative matters, it's possible that there are individuals who would be targeted by that initiative who might have
So
standing.
the only, like in this case,
So-
for example, the only person, sorry to interrupt, but someone might be someone who was going to be on a ballot and was opposed to ranked choice voting. They might have sort of.
That's
Article III
possible.
standing.
The DC District Court recently ruled in the Hall case about standing with regard to Hall, who claimed this was a challenge to the non-citizens voting rights. That Hall didn't have standing even though she claimed she was a prospective candidate. But there may be circumstances where somebody who is a prospective candidate could make a standing argument.
But so then.
With respect to this initiative, but again, there are other initiative matters that may target particular populations, and it's possible that you could have an individual who would be so affected by that
doesn't this
initiative that they would
initiative-
have an injury.
Doesn't this initiative, I mean, I don't mean to use a charged word, target, it impacts everyone.
That's
Because, I mean. and
partly the
that-
flip
that-
coin of it not
But-
having a
But
standing.
that is, well, no, I mean, it's the nature of this initiative is how your vote is counted, right? We are changing how your vote is counted, right? With the ranked choice voting. So the nature of this initiative is that it affects every single voter in the District of Columbia. And
Right.
you're saying.
and there's-
And so you're saying if there's clear evidence of fraud and abuse, that no one has standing because this voter initiative affects everyone? I just find that surprising.
Well-
Do you,
Let me give you a hypothetical and see what you, so let's imagine that the board, there'd been no challenge at all. And then the board comes to a hearing and there's a public hearing. And the board, the staff of the board says, there's this initiative that's been presented and there are some signatures in support of it and there's like 7 signatures. But we don't really care. We think you should put it on the ballot anyway. And the board says, good idea, let's put it on the ballot. And some voter thinks that's crazy. I mean, that can't be right. There was no challenge because nobody knew this was going to happen. But then all of a sudden, here it is. Here's what happened at this public hearing. You're saying nobody has any way of remedying that?
No,
because it's
no,
a
I'm
general
not saying that.
restriction.
I'm
So-
not saying
okay,
that.
so-
I think
you're
that
saying
the remedy in that case would be to go to the Superior Court with a writ of mandamus compelling the board
And
to
you
do
think
what the
that-
law
but someone
requires.
individual
has,
voter would
someone
have
has
standing to do
standing to file that writ of mandamus. Right? Because let's
I
not
mean-
get to remedy. Let's stick.
I
with
mean, they would
standing.
have to make out a case of how they were injured
Right.
by that fraud
Someone
somehow,
has-
right? I
someone
mean,
has
it's
standing.
Yeah, but that's
conceivable
the
they could do
question.
that.
How would they make
Right.
that out?
Well, I don't, I don't think that she's injured by letting people vote on this initiative.
But that.
Even if you assume that it was wrongly put on the ballot, I don't think,
Let's-
the
let's-
harm is if the council enacts it. And
let's
so her
stick-
remedy,
Well, no, that's not
might
right,
be-
because I mean, if it never gets on the ballot, then if you're Miss Brown, you're better off than if it gets on the.
that's true, but in
Right.
terms of
So-
standing, the injury has to be direct and, immediate. And the injury isn't direct and immediate when you've just gone through one step in 10 steps
So then your
to
answer,
finally implement.
your
your
answer
answer-
to Judge McLeese's hypothetical then is a little different. You're still not explaining why someone might have standing at the ballot stage, at putting it on the ballot stage. You seem to be saying that no one has standing until it gets voted on.
There may be circumstance where somebody could develop, I
Well, wait,
just
I
can't.
just want to really take us back to Judge McLeese's hypothetical, which is, the ballot initiative goes before the board. It is clearly does not satisfy the statutory requirements for a ballot initiative, which requires, 5% of DC's population to have signed signatures in support of putting it on the ballot, and has distribution requirements for, so many signatures in each ward, right? It clearly does not meet those, and nobody thinks it's going to go through, and yet the board, in dereliction of its duty, says, fine, let's put it on the ballot. And it is that clear, and you were saying, because it's only a ballot initiative, and because it's not clear that people will actually vote for it, no one has standing to challenge that.
There may be an argument, perhaps, that as a taxpayer, the cost of running the election and doing the work to put that on the ballot might create standing. I'm not
You don't
researched
think there's
that, whether
voter
that would
standing?
be
You don't
enough.
think there's voter standing to say, you know, there's this, I'm now being put in front of me is this thing that should never be there.
Yeah, I mean, that's the whole point of standing. There has to be some injury. There has to be some case and controversy. If nobody's being injured by it,
Well,
then why should the courts entertain it,
Can
right?
leave aside standing for a minute and moving on? This may not be load bearing because it seems as though Ms. Brown is not conceiving of the case as a continuation of her specific challenge to the petition. But I want to just make sure I understand how the board thinks that went. So she submits a petition challenge
Mm-hmm.
and the registrar writes her a letter saying, I'm not accepting this for filing because it doesn't meet the regulatory requirements. Is that a decision of the board? Or is that, is that the board rejecting it or what is that?
The regulation says that, and she actually signed a form saying that, the challenge she was submitting would be numerically sufficient. The regulation states that the board shall adjudicate the validity of each properly filed challenge. So I think that it makes, at least the inference of the regulation is that the board only adjudicates if there's a properly
Right, and
filed challenge.
what in the regulations or elsewhere, or the statute says if a challenger submits a challenge to a petition, the registrar has the authority to reject it as opposed to the board?
Well, if the board doesn't make every ballot access decision. If that were the case, we couldn't function. I mean, there are a
Right.
number of
I'm
ballot
just
access.
asking,
you
is there
know,
anything
right?
in a regulation or a statute that authorizes the registrar to make a decision about whether a challenge is properly submitted? And if your answer is, I mean, it sounds like your answer is no, but it would be impractical to do it otherwise. That may be a good answer. I just am curious about, is it right?
I
that
think
as far as you
that's-
know, no regulation or statute says that.
That's always the way it's been applied. If you don't file a proper challenge, if you don't file a proper, on its face, there's a
But is
preliminary
it right
determination.
to say, as far as you know, there's no?
But there's nothing specific that
specific
says that the
regulation.
registrar does it,
And let's
yes.
say that I file a petition and challenge, and the registrar writes me a letter saying, we're not treating this as filed. It is defective in the following way, and I don't agree. What do you think my remedy is? Can I say to the board, the registrar is saying that this is not a properly submitted challenge, properly filed challenge, but it is. Board, I want you to rule on that. Is that an option I have, or do I have to accept only what the registrar says?
Well, two things. One is that she's not making that argument. She didn't make that argument.
well understood.
But secondly, there are procedural rules in Chapter 4 of our regulations about requesting, making a complaint, filing a pleading. You have to file a formal pleading. You have to identify what area of the law you think was violated. So she could have arguably followed that
So she
procedure.
could have filed a complaint with the board saying and
Yeah.
I looked at those provisions in Chapter 4.
Right.
And so you think that you agree that there ought to be some way to get to the board if you think the registrar is wrong in refusing to submit to
Yeah.
accept your challenge.
Anybody can always file a complaint
And so
to
they
the
can
board,
complain
as
to the
long
board.
as they do it properly, as long as they have a pleading and they lay out what law they think was violated, that would be presented to the board, right?
And so you don't think the board really ever ruled on the adequacy of her complaint because the registrar, her challenge, her petition challenge, she never
Right.
filed a complaint because the registrar said, sorry, I'm not accepting it. And then she never sought further review of it.
That's right.
that
And she
right?
never even came close to arguing that I think you made the wrong decision. She instead asked for this other procedure, an emergency hearing.
And just to follow up to make sure I understand how you think the challenge process works. If I'm a challenger who's filed a challenge to petitions and the registrar says, sorry, it's not adequate, we're not treating it as filed, and I go to the board and I say, board, you should look behind what the registrar did, that's not right. In fact, I submitted an adequate challenge. And the board says, no, we agree with the registrar. And I think, well, I don't agree with the board or the registrar. Can I get judicial review under the provisions that eventually refer you back to the provisions relating to nominations and the like?
So,
I would have review in this court about the correctness of that rule.
so yes, because a complaint under Chapter 4 would trigger hearing procedures and as sort of an adversarial process. So the matter would be heard before the board.
Well, I'm not entirely sure.
And it would issue an order on that.
Well, I guess
I mean, the board under law can only act, it can only issue decisions at a, public forum.
I'm a
So-
little unsure about that only because the statutory provisions relating to challenges to petitions send you off for judicial review and for the further proceeding of challenges once they're filed to the whatever is 1001.8
Mhm.
procedures that
Right.
relate to qualifications of candidates and the like, right?
Right.
And that's like 1008.
Oh,
Right? So I'm
Yes.
trying to get to O. And that seems to say that you can challenge. So that seems, I'm sorry, now I'm in the wrong one. I'm in 1016. I wanted to get to 1008.
8. Oh, yeah.
There we go. Right. It says, it has somewhat different procedures. It seems to say if you submit a challenge, it has a similar requirement of it has to specify concisely alleged defects,
Yes.
which is the source of the regulation that has more detailed requirements.
Mhm.
So I get that. Then the next sentence seems to say that those challenges should automatically be served on the proponent,
Mhm.
which is different process than I think what happened here at least, right?
Right.
Because that wasn't done. And then it says, the board shall, receive evidence in support of the challenge, determine validity. So it's just a little unclear to me whether review by the board of a complaint that the registrar is refusing to accept a challenge has to go through the Chapter 4 stuff, or instead goes through the 1001.06.
I mean, right.
Provisions seem different. So I'm a little
Right. This
puzzled
is
about
kind of a novel situation, but I think my gut reaction would be that it would be under Chapter 4,
Yeah, I was
right?
just
Or
worried
the
about
Chapter
that.
4 procedure, right?
that. While we're in the regs, can I just ask you one other question, which touches on a concern that your opponent has raised, which is about the board's failure to issue a written order saying we are hereby approving, I forget if that's the exact correct
Mhm.
statutory term, but we're hereby giving the green light to this initiative. When I was looking at the regs, it seemed like there is a reg in, I think it might be in 3 DCMR 104.01 that seems to imply that the board's order should be written. Are you familiar with that reg or?
Yes, but I think the whole Chapter 4 concerns hearing proceedings, right?
This
That's
is a
what.
general reg in 3 like 104. It's not in
Oh, in the
but it's
general
not in-
sections, yes.
Is it common for the board to decide questions like this orally without ever issuing a written order?
Yes, it is common. I know she says that there's a practice of the board. Well, I can't say it's common because initiative matters are so rare. But there isn't any practice of the board issuing orders in certifying initiatives to go onto the ballot. In the past 20 years, there have been about 20 initiative matters that actually got to the level of getting a petition issued and going on to the ballot. And in those 20 cases, there were only 6 that I think were certified onto the ballot. And in only 2 of those cases did the board issue an order, and it issued orders because there was something else special going on. In one of the instances, the board was also deciding a challenge, which is a contested case matter that you'd have to have a hearing on and issue an order. And so the order both addressed the challenge and certified the measure to go on to the ballot. And the other case was Initiative 82, where there was this problem in certifying to go on the ballot where we could not reach the statistically required level of certainty in all of the wards. And the board exceeded the 30-day time limit for making its decision on certification by quite a bit. We actually had to go through and check all of the signatures in one particular ward where they couldn't get a 95% level of confidence as to the signatures. And it took a while. I think the decision was supposed to come out on March 24th, and the board didn't issue the decision till April 6th. And so the board issued an order in that particular case, and part of the purpose of the order was not just to address certification, but also to explain why it was reasonable and fair to have taken more time than the statute required to make the certification decision.
To be specific about it, the reg that I was referring to is 3 DCMR 104. It's entitled Orders of the Board, and 104.1, which it's not entirely clear that this is applicable, but
Right.
at least it's potentially says the chairperson shall approve or disapprove board orders in writing with his or her signature as may be appropriate, provided that written orders issued in matters heard by a single member shall be signed by that member.
Yeah.
That at least arguably that suggests. that the
Arguably, I
board
think
should
we've always treated certifications, decisions as not really orders. You know, you certify, you're ministerially required to certify. It's not like you're.
How's that? I was hung up on the word ministerial, and this gets back, I guess, to the other path, which has its own procedural problems. But in what sense is the determination of the board to, so the board gets a report from its staff that looks into, here are all these petitions, and here we have all these requirements that here are all these signatures with respect to a petition, with all these requirements that we have to sort out in order to figure out whether, or the recommendation of the staff to the board is, yes, this is all fine, and you should go ahead and put this on the ballot. Why, it strikes me as, I mean, it might practically not, if no one is there objecting and it all seems, fine, then the board won't have, much to have to practically fight through. But it seems to me it's potentially not at all ministerial. I mean, if let's say the report was, this is a difficult question, and these are the considerations, and we've ended up thinking this. Are you saying that the board is sort of a ministerial rubber stamp? That seems and if so, what in the statute suggests that the board lacks authority to say, well, thank you for your report, staff, but we see this issue differently, and we're not going to put it on the ballot.
Well, the statute says if you find that the petition is numerically sufficient, you have to certify to put it on the
Good,
ballot.
if the board does, though, you're saying the board ministerially has to accept the staff's recommendation about whether it's sufficient.
And just to put a finer point on Judge McLeese's question, right? I mean, here, there was this question about the whiteout, the use of whiteout, and when certain signatures would be discounted, or certain information that had been whiteouted would be discounted and when they wouldn't. And that doesn't seem ministerial at all, right? The staff made a decision. Well, the staff made a decision saying, well, when we can see that the address has been changed, we will not accept that signature. But if it just looks like they've, turned, Mass Ave into Massachusetts Avenue, then we'll keep that. And if we can't tell what was changed at all, we'll discard it. That seems like a very discretionary decision and not ministerial at all. And so if that were the basis, right, for deciding whether, and I understand that that's, that these were the board staff decisions separate and apart from the challenge that was made by Ms. Brown, but pretend like that was the decision-making that happened prior to the certification of this petition as a legitimate petition that should go on to the board. That doesn't seem ministerial to me. Why would you think that those sort of discretionary calls are ministerial?
Well, every single signature is a discretionary call by the staff, right?
I'm not talking about every single signature. I'm talking about the sort of the rules that the staff created for themselves to say, if we think that they are changing the address, we will not accept the signature. If we think they're just sort of modifying an abbreviation, we will. If we can't tell, we won't accept it. Those are 3 buckets, 3 rules for analysis of the signatures that the staff themselves came up with. That doesn't sound ministerial to me.
I don't think that those decisions were highly discretionary decisions. You have to count a signature if the address matches.
But there are other ways. I mean, I'm not casting aspersions on the staff, and I'm not, suggesting that these were bad rules. but they do seem like discretionary rules. Like one could say, look, if I can't tell that anything's been changed, I'm going to count the signature because I can't tell that anything's changed. Instead, the staff erred on the side of caution and said, we can't tell what's been changed. It's whiteout has been used. Therefore,
Right.
we're booting the signature. That's a discretionary call. It doesn't seem ministerial.
And the same thing can be said of checking signature validity, we have to check hundreds of signatures against what's on the voter roll. And that's a very discretionary decision and that
I
happens
think you're
with
sort of
every
missing,
initiative.
I think you're missing my point,
No,
right? As far as like deciding, here's how we're going to do this. These are our analytic rules for analyzing the use of whiteout. They made discretionary calls that I would not label as ministerial. And so to the extent that you are saying that the approval or the rejection of a complaint as satisfying the basic minimum statutory standards is ministerial because they relied on these rules, it doesn't seem ministerial to me.
So let me just say this, if the board had disagreed with the staff's decisions and decided not to certify,
But at what
that-
point, I guess
that,
we haven't even heard that the board had an opportunity to do that. Right? Here, it seems like the registrar made that decision not to certify a petition.
but the board could have, there was no reason why the board couldn't have second guessed what the registrar did. There have been
Is the
other.
board given
there-
an opportunity to do that? Is that in the normal course
So
before the
in-
registrar says, I'm going to reject this complaint as not statutorily compliant or whatever the sort of the properly, it's not properly filed.
So,
Does the board review it first?
let me just back up for 1 minute and just say.
Can I just get an
because
answer?
there's-
Can I get an answer to my question?
I'm sorry, could you repeat your question, Your
Right.
Honor?
Here we have a letter from the registrar saying that a petition was not properly filed. And so therefore it is not going to go on to the regular process before the board. But I thought you were suggesting to me that the board in the normal course would first review to determine whether this properly filed designation was correct by the registrar. Is that what happened?
No, that's not what my point was making. I was talking about after the board has done its independent review at the point of certification, whether the board goes
Right.
back and
We're
refuse the
way before
registrar's
that.
finding.
We're back at the
Okay, I'm
properly
sorry, I
filed
didn't understand.
challenge.
Okay, I'm sorry.
I thought that you were saying that whether or not a petition was properly filed was a ministerial decision.
No, that's not what I'm talking about. I was talking about whether or not the petition meets the sufficient number of signatures
It may
to
help
be
to clarify
certified.
technology too, because I think there is, what Ms. Brown filed was a challenge, I think is the term that the regulations use. So the registrar said this is not a properly filed challenge.
Right, she used our challenge
So what she was
forms.
filing isn't,
Right.
at least the regs don't call it a petition, and petition it also comes up at other phases, so that may be generating some of the confusion back and forth.
Right.
But and I gather is your answer to Judge Easterly that if a registrar says this is not a properly filed challenge, the board doesn't normally get involved in that.
That's
Is that right?
correct, unless they were to pursue,
If
as we
somebody
were talking about,
somehow-
some complaint
some other way
remedy,
of-
right?
yeah.
Yes.
But so, and if the board did get involved, you would agree that the board's involvement would not be limited to a ministerial function.
Absolutely not. No,
Right.
it would be highly discretionary and that it would issue an order that could arguably be appealed to
Now,
this
going back
court.
to the other phase of it, so let's talk about the track where, leaving aside the challenge, which may have been abandoned. And instead there's someone who just comes in and says, I have concerns, board, about what's going on with this initiative process, and I'd like a hearing. And then shows up at, the board's regularly scheduled public meeting and raises concerns orally. And at that hearing, the board, in its independent review process, is given information from the staff. And it looks at that at the beginning of the hearing. In this case, it votes to
Mhm.
agree with the staff and say, this is fine, we're gonna go ahead and put it on the ballot. And you had seemed to say that the board's function at that stage is ministerial in character, and I was expressing some concerns
Right.
about that. And so it seems to me that it could be not at all ministerial. It could depend on how you resolve questions of law that the board might have to sort into.
Mhm.
It could also turn on questions of fact, which are ministerial in character.
Mhm.
And so let's imagine here that the staff had been persuaded that this whiteout is really a big problem. And in fact, let's say the staff recommendation was along the lines of some of the concerns Ms. Brown has raised, to say any circulator who's whiting out stuff is not a reliable circulator. And we've thrown out every signature that was gathered by a circulator who used whiteout on anything. And so our recommendation to you, board, is to do that and to not put this on the ballot.
Mhm.
You would agree that if the board goes to the meeting and it says, well, that's not a ministerial question. That's a question of like, do we agree with that? Is that a sensible approach to interpreting what the validity is of signatures for purposes of this? That's partly a legal question, and they turn also on factual questions, and the function of the board in its independent review capacity could be far from ministerial. It could, if it wanted to, I assume it could take evidence on the topic and say the staff is recommending something, but it seems like they're factual questions and we can't really determine whether to accept the staff recommendation or to do something different, and whether to certify or not, if that's the right term, but pass it along and put it on the ballot without holding an evidentiary hearing. Or they might say, well, we just think the staff took an approach here that reflects an incorrect view of the regulations of the law about when to disqualify signatures, and our own view is quite different, and we're going to follow our view of the law, not the view that's reflected in the staff recommendation. So if you agree that those are the kinds of things that the board can do, then I think it would follow, and I'm curious what you think, whether you also think it would follow, that the board's function is not necessarily ministerial. It might be ministerial in a case where nobody could reasonably dispute anything that the staff was recommending, but it's not ordinarily ministerial. It's not like the board is a clerical minion of the staff. I assume that the board needs to make its independent determination about the correctness of the recommendations of staff.
And that sort of
But
happened
do you
with
agree
respect.
it's not correct to call the board's function ministerial, or do you continue to think that ministerial is an appropriate word?
Well, I think that, again, that it's appropriate to refer to the decision to certify based on a finding of sufficient signatures by the board.
By the board.
What's ministerial, but there may be other issues that the board decides in the context of doing that, and that's with I-82. And the board issued an order. There were lots of issues that came up at the hearing on I-82 that were decided.
I can agree with you that once the board has made a determination, non-ministerial in character, that there are a sufficient number of signatures, then the statute requires them to put it on the
Right.
ballot. It doesn't give it some free-floating discretionary authority not to put it on the ballot. So in that sense, once you've made the findings, it's ministerial to certify. I'm with you on that,
Right.
but it's not, I don't think, ministerial for the board to determine whether the statutory requirements have been met with respect to the number of signatures and their distribution and all that.
And that's correct. And where that has happened, the board I mean, again, there's so few instances where initiatives get to that stage. But where that had happened in I-82, the board did issue a lengthy order, and I believe it was appealed and litigated because there were a lot of arguments about how they used the wrong, the proponents claim we used the wrong sampling for different for signature verification for certain wards, and there was a lot of back and forth about that. And the board issued a very lengthy order addressing those. And that could be the basis of some sort of court action. But the ultimate act, once you make that determination that you have enough signatures, is ministerial. That's our only
Can I ask you
point. And that's what's happened here, right?
Can I ask you, I know if we are conceiving of this as an effort to seek judicial review directly in this court of the board's failure to grant an emergency hearing and decision to certify. I know you have arguments that Ms. Brown doesn't have standing to seek judicial review of that anywhere. And I think you, if I understand your brief correctly, you also suggest that the only statutory, there's no way to get there from here. At least your brief suggests that your answers to the argument suggest maybe you don't fully go all the way down the end of the road of this, but that there is a statutory way of challenging the putting of initiatives on the ballot. That's the challenge process. That's the only way of challenging it. It sounds like you think perhaps if someone had standing, in some settings, if they couldn't have made a challenge before, they might be able to seek review. But do you agree that to the extent there is any kind of review available here, it would be in the Superior Court rather than this court, because whatever review there is there would not have some contested case authority in it?
Right. I mean, this court has recently said that litigants have authority to go to the Superior Court in equity jurisdiction. So I mean, in light of that recent decision, I would have to say, yes, you should be able to go on an equitable theory into the Superior Court
Right.
if
My-
there's
my-
no
my question is
remedy
less whether
under
you
the
concede that
statute.
that's a viable avenue, but just if it is an avenue, it should be that court rather than this one.
I'm sorry, could you say your question again?
Yeah, I'm just trying to
Your
figure
Honor?
out whether you think, assuming there is some way that someone who was not a challenger could say, I want to seek judicial review. I'm aggrieved in a way that may confer standing, and I want to challenge the board's decision to certify initiative and put it on a ballot. Do you think that if there is such an avenue of review, it would be in the Superior Court rather than directly in this court?
Yeah,
because it would
yes,
be a
I think
contested-
that would be the proper form
Okay,
to go to
one other
first.
question, at least for me, which is, I know you talked about the Chapter 4 procedures about filing a complaint. If Ms. Brown, rather than sending an email saying, I'd like an emergency hearing, and then appearing at the general public hearing and making some comments, had filed a complaint with the board saying, here's my complaint. There's this thing going on with petitions, and I know you're in the middle of independent review, and I am complaining, and I want you board to act in response to my complaint, that the signatures are, there's whiteout, and anything that has anything to do with whiteout should be gone. Would that have how would that have spun out? Would the board have had authority to
So-
address the issues in the context of a complaint like that? Or would they have to say, no, the only way, we can't have complaints meddling with this process. There are two things that can happen. One is a challenge. The other is our independent review, and people can't come to a third way and say, by the way, I have a complaint and I'd like to trigger all the complaint procedures. I'm just curious how that third avenue fits into the first two.
So as long as she filed a valid complaint, it would go before the board, and my gut reaction would be the board would find, as your honor has said, you had an opportunity to file a challenge, you had a 10-day challenge period. It was your burden to identify all of those signatures. You file on the form for signature invalidity. You were making a signature invalidity claim. You needed to come up with a sufficient number of invalidity signature claims in order. But that's not to say that the board wouldn't also comment on the whole whiteout issue and what its position would have been on the whiteout issue as well.
And that,
you know.
that happened at the hearing in the sense that staff made some comments about it, and at
Right.
least the chairman of the board also made some comments that he at least was relatively content with how staff had handled the whiteout issues.
Right.
But there was never a ruling of the board.
Yeah, I mean,
on that question, as far as I could tell.
I can't imagine, I mean, I'm kind of just speculating here, but I would assume that the board would want to address those concerns if the forum was, if it was a properly presented complaint, so. I just want to make one quick comment about the discussion earlier, because there might be some factual confusion. Just to be clear, that we did discount all of the petition sheets where there was whiteout on the circulator affidavit. So those were thrown out. What we're talking about here is whiteout that was used to make a non-substantive change. Whiteout that did not change the address that the signer put on the petition. And the example we use is where the signer abbreviated Massachusetts Avenue as MASS period, and Mass was whited out and Massachusetts was written out. Those are the signatures that Ms. Brown is claiming should have been discounted. They were otherwise valid, other than for the fact that somebody used whiteout to clarify.
She also has another claim, which is any circulator who was in the business of doing whiteout ought, and that was maybe belated in
Yeah.
the sense that come up in this court, but that's a claim that
Yes.
she is presenting now, is this idea
That's-
that any circulator who will stoop to whiteout really should just be dead to the Board of Elections and all the signatures collected by that circulator should have been.
Yes,
identified.
I agree, because in her reply brief, she makes very clear she's only asking about a limited class of signatures that were actually had whiteout on them. And here in oral argument, she's now saying she wanted all those sheets thrown out.
I thought in her
But,
opening brief, she also said that, but maybe I misread.
well, if you look at
Yeah.
her specific prayer for relief in her reply brief, she just says she wants the court to order the board to toss out the signatures where there was whiteout used, not to toss out the entire sheets. But be that as it may, you know, Williams and Citizens Committee talk about when the board can, you know, should be allowed to throw out an entire sheet. And I think it was the video lottery case, and Judge Ruiz in her concurring opinion says that it would have taken Williams too far to throw out petition sheets where the board knows there wasn't any real misconduct going on. And I think that, you know, in light of that, the board's remedy was appropriate and consistent with the guidance from this court to accept those signatures where the signer would have otherwise been valid other than for these whiteout, and to toss the ones where the circulator tried to basically update the address of the signer without going through the requirements of the regulations of submitting an updated voter registration form.
All right. Thank you, Ms. Pembroke.
Thank you.
Appreciate your time. Ms. Brown, we'll give you just a few minutes.
Sure. I just wanted to leave the court with a couple of thoughts and some clarity here. Listen, what we're talking about today, and the reason I'm here is for you to review an agency's decision. And when they certify this as numerically sufficient, the question is, was it? And we don't know, because we still do not know how many signature lines were left in because they said it was okay, right? Because I don't understand how the Board of Elections can make up rules about how to okay fraud. If you use whiteout on petition pages, for whatever reason, that is fraud. And so I would ask them to please give us an administrative order where they outline their process, which lines they whited out, which lines they kept in, and for what reason, and they haven't. Ms. Pembroke said there's something else special. Well, this was special. They knew at least 4,802 lines had whiteout. They knew that there was fraud prevalent through this petition process. That's a reason enough to give an administrative order, not to mention that the chair of the opponents asked you to. The other thing is she spoke about this not being a ministerial act, but it was, right? They obviously used discretion. She goes through the whole thing about how we kept some in, some out, we held it up to the light, right? So this was not ministerial. This was a situation where they decided on their own whether or not something should stay in or not, even though, once again, fraud was rampant, used whiteout. For standing, one thing I want to say is, once again, I'm just asking you to review this decision that was made. So about having to go back to Superior Court and being contested, I don't think that's valid in this case. I do have injury or harm as not just as a voter, but also, once again, as the chair of the Vote No Initiative 83, which is the opponent to this. And then also, I also have standing because I was petition watcher, and that's the whole point of that process. I thank you for your time.
Thank you, Ms. Brown. Thank you, Ms. Pembroke. We appreciate your arguments today, and this case will be submitted. The third case on our calendar today is 24 AA 526. SHEA YELEEN Health and Beauty LLC et al. Versus the Office of Wage Hour et al.
May it please the court, Sarah Hogarth for petitioners. I will endeavor to reserve 5 minutes for rebuttal. The wage payment and collection law is a remedial statute that targets very specific wrongful employer behavior, deliberately failing to pay undisputed wages at appropriate intervals. It punishes this conduct with extremely severe penalties, including treble damages and attorney fee shifting. But the WPCL does not pursue its remedial ends at all costs, and it does not and cannot govern every dispute that might arise between an employer and an employee. In retrofitting the WPCL onto the fact pattern here, the ALJ made several critical errors, and at the end of the day, Ms. Beck has no uncompensated wages or damages cognizable under the WPCL. I'd like to start with the burden of proof that the ALJ applied, and the burden of proof here is supposed to rest upon the complainant. Beck must prove that she, in fact, was an employee who performed work without appropriate compensation. The court set forth in Bongum how this burden operates, and that burden shifting does not apply until an employee has demonstrated that they had work that was not timely compensated. And the failure to maintain or produce employment records does not vastly minimize that initial burden of proving the fact of some kind of harm. So the ALJ then used this concept that there was a burden shift to break nearly every issue in the complainant's favor. And that is contrary to how the burden of proof operates in this context.
But your argument as to Ms. Beck's failure to meet her initial burden presupposes the correctness of your client's assumption or determination or argument or position, however you want to put it, that Ms. Beck was an independent contractor. And so it can't be that a claimant fails to meet their initial burden simply because the employer operated under the assumption that the employee was operating as an independent contractor, right? And so in some respect, the employer bears the risk that if they treat someone as an independent contractor and they end up being wrong under the factors that we apply to determine whether someone was an employee or an independent contractor, that they could be liable under the statute ultimately, right?
So I don't disagree with that in general. And this court did find that she was an employee for certain activities. But when you take that sort of dual hat analysis that this court applied, the person needs to show, well, these are the employee activities for which I did not receive appropriate compensation.
And why is that? I mean, why shouldn't the burden be on the employer to say, well, we had them working as an employee statutorily, but we also had them working as an independent contractor, and it's on us to show which was which.
Well,
right?
I don't think that's what this court.
If they give the employee, these two sets of tasks, it seems like maybe the employer is the one who needs to keep the records and make sure that they have the lines drawn clearly.
So a couple points in response. So I think even under the Bongum framework, it is the employee's responsibility to demonstrate employee activities. So I think that naturally applies when you get into the dual hat
But we
function.
know that this, I guess I'm wondering, like, is there anything in the statute that you can point to me when you have this hybrid situation, right? Because here we know that this petitioner was operating as an employee to some degree, right? That's what our prior decision in this case held. So on remand, the question was, well, how much, right? And now we're talking about burden. So is there something in the statute that indicates that, well, now that we've determined that this person was acting as an employee to some degree, it's on her to show how much she was acting as an employee? Why would that make sense given sort of the general understanding of the law?
Well, I think that follows from all of the court's cases analyzing kind of where the activities flow.
But so there's nothing in the statute that you can point
Well,
to.
I think the burden shifting statute actually supports that too, because it talks about showing the employee time. And if we're interpreting under this court's prior opinion, employee to mean when you're doing certain functions, you are an employee, the word employee is taking that meaning. And so the person who says they're an employee needs to continue to show throughout that which activities are employee activities.
Actually, when you say the burden shifting statute supports that, you've said some things about it without getting into the exact subsections
Sure.
or language you were focused on. But if we're talking about 32-1308.01 E4,
Yes,
so if we're oriented there, so it originally places the burden of proof by preponderance on the claimant. And then it says it shifts to the respondent and it doesn't say, about what. Just sort of, I presumably generally all the topics that the statute is focused on here. And it's, shifts if certain conditions are met. And the first is the respondent failed to keep records, which I think is undisputed here. I know you make the kind of equitable point that nobody thought she was an employee originally, and this agreement between the two of you had her obliged to keep records. But I think the way the statute is worded, that means that if you are an employer and it later turns out that everybody was wrong and you had an employee and you didn't keep records because you didn't understand that you had an employee, that is going to be that's sort of unfortunate for you, and you'll, at least the first part of this burden shifting provision will work unfavorably to you. So then we get to the part, so I take it as relatively undisputed that there weren't records kept, and that the wording of the statute at least then says if Ms. Beck can meet the second piece of this requirement, the burden would shift to YELEEN. And that is, what the ALJ found was that Ms. Beck had presented evidence to show, as a matter of just and reasonable inference, the amount of work done. So on like how many hours were employee hours and how many hours were independent contractor hours, the statutory language seems to, if the finding in B is supportable, seem to place the burden on your client. Am I wrong somewhere? I think you may contest that the record permitted the ALJ to find that Ms. Beck had shown, as a matter of just and reasonable inference, the amount of work done. So I get that point, but assuming that the ALJ found otherwise, and assume for a moment we agree with that, then do you agree that the burden on, at least on how many hours were employee hours and how many hours were independent contractor hours, the burden would be on your client, or do you think that's not correct? And if you think it's not correct, why under the statutory language? I understand Bongum has some kind of broad language, but it doesn't really zero in on this provision, as I recall, at least.
yeah, so the point I'm trying to make is that it's about the word employee, and this court construed the word employee.
I'm sorry, the word employee where?
Yeah, so even in A, respondent failed to keep records of an employee's hours. It's contemplating that there's got to be an employee.
Right, we already said
That's
there
what
was.
Sure, right. And then now we're at the point of, well, there is for certain functions. So where does the burden fall to show what is employee and isn't? And I think that
So
remains.
is your argument that it's her burden to show which hours were employees' hours
Sure.
under the statute? So then what does the burden, if that's the way of reading it, which is in order for the burden to shift, you have to show all the hours you worked. And if you haven't done, if you can't show your employer failed to keep records relating to your employee hours, the burden doesn't shift. It seems like it would then be a nullity. And again, also the provision here is about whether the respondent failed to keep records of an employee's hours. And it is, I think it's undisputed that you didn't keep any records of any of her hours. So I'm not quite sure how the word employee in that phrase is helping you resist the shifting of the burden to your client.
Okay, so just a legal point on this burden shifting. I think first, this is a damages burden shifting. It's basically directly copied from Anderson versus Mount Clemens. So I think even just how to think about this section is one, you have to establish the fact of damage first before you even get to this kind of damages burden shifting. But all I'm trying to draw from this is I don't think anyone disagrees she needed to show employee. When we get into this world of you can have two hats to continue
I
to
think
show
I'm
employee.
I'm not understanding your point about Anderson and that this being a damages provision. That maybe I'm missing your point, but this is in E1, which is just all about sort of the administrative hearing that you have before an ALJ. And it's saying, you know, this is how this is going to work. This is the power that the ALJ has. They can, you know, take evidence under oath, and everybody shall appear with or without counsel. And the burden of proof is on the complainant, but shifts if these conditions are met that Judge McLeese has drawn your attention to. So, and we've already determined that this petitioner was working as an employee, and it seems undisputed that your client didn't keep records of their employee hours, didn't keep records whatsoever. So does your argument turn on 4B, or I'm not following what your
Yeah,
argument is.
this structure just tracks what the Anderson versus Mount Clemens structure is, which is that if there's a lack of adequate records, this is how you ascertain damages. So the statute is like copying that language from the Supreme Court case. Then this court described this all
But
in
it
Bongo.
doesn't say that it's limited to damages, as Judge McLeese pointed out. It just says generally the burden of proof is on the claimant or the petitioner unless these conditions are satisfied.
Yeah, and it
So
would be-
are you saying it just doesn't apply to this scenario? Or are you saying it applies to this scenario, but it applies in a way that favors your client? I'm not understanding what your argument
yeah,
is.
it applies once you get to the damages question, and our principal
So you're saying
submission.
it's premature to apply it right now? And
Yes.
I just don't, why is that under the language of the statute?
So the language of the statutes.
I mean, I know you're
incorporating-
telling me that it's borrowed from this other case,
Yeah.
but sometimes we borrow language from another case and we use it for different purposes. And here, there doesn't seem to be any limiting language in here about the use of this burden shifting principle. So even though you're telling me that the legislative history is that it came from Anderson, doesn't seem to be codified in that way.
Well, I think this is how the court talked about exactly this language in Bongum when it was talking about where the burdens sit. So I think it's all reflective that this is like a damages
But
legal.
as
But
Judge
isn't
McLeese
this
has
all
already
about,
said, Bonham didn't really zero into the scenario that we're talking about now.
Of the dual hat.
We've never confronted that before.
Yeah,
but-
that's definitely.
but
true.
aren't, I mean, this is all about damages anyway, right? I mean, it's ultimately a damages statute at bottom. And so, I mean, your point seems to be more that someone can't even get through the front door under this provision if they are if they're an independent contractor and not an employee. And so this only comes to play when you're calculating damages, but I mean, isn't Ms. Beck already through the front door by virtue of the fact that we are in a world where we've determined that she was both an independent contractor and an employee?
Right, but there's.
Now we are talking about damages ultimately, right?
Well, I think there's a dispute about which activities made her an employee once you superimpose this dual hat framework. And so if she started out with the burden to show she was an employee, I think that was accepted in the prior case. Then when you get to which categories and activities make her an employee, she retains that burden.
Why, see, I don't get that. And I mean, the two issues that are as discussed, as you get into subsection 5, you get into the word damages and some other things about, you know, how that all works. But the two issues are really about what the damages would be. The two issues that are referred to like in 4B, which are how many hours did she work as an employee and how much was she paid for that work, and when would be relevant to, relative to statutory penalties and treble damages alike. So those are both part of the damages calculation. And why do you think the burden shifts on the calculation of hours? Or maybe you don't think it shifts on either really, but I mean, at times I think at one point you said you can't get into this statute unless you have already shown some kind of damages. And it seems to me like this is shifting a burden for the process of figuring out whether there are damages, and if so, how much, by figuring out how many hours were worked as an employee. Again, assuming there's a showing that at least some were, how many were, and then how much did you get paid for your work as an employee? This is designed to shift the burden to allow people to calculate that in a burden shifted setting where its requirements are met. So the idea of there's a prerequisite of some kind of a showing about damages before these burden shifting provisions kick in seems structurally confusing to me. So if that's your argument, I haven't quite got my head around it yet.
Yeah, I mean, I think it's very usual that a prima facie case would include the fact of some damage. And then there's an attempt to figure out how much.
But where do you see the idea in the text of this that the burden shifts only if all these statutory things are true, and also the complainant has made a prima facie case that at the end of the day there were some damages when these calculations are made? I just don't see that in the structure or text of the statute.
Yeah, so I think it's the court's opinion in Bongum construing the wage payment and collection law and describing exactly this language and how it operates, and requiring that a complainant at least show some inappropriate compensation in order to get the burden shift. So that's point one. I think that's what this provision is getting at, exactly what the court described in Bongum. So I think that should be applied. And then the other piece is, we all agree that the word employee, she has the burden to demonstrate that. And so in trying to show which activities were employee or not, she retains that burden, rather than having that shifted. I think the other point on the statute is it's 1308.1E1, and that's talking about the ALJ is supposed to find a violation of the statute. So I think that further supports that there needs to be some showing that is antecedent to just what are the measure of damages. You need some fact of uncompensated wages.
On the Bongum point, can you just point me where in Bongum we zeroed in on, like, trying to parse what we were saying with these statutory provisions and their language? I'm just trying to find it.
Yeah, so
I'm struggling with it. Not to say it's not there. I just
yeah, so like 1163 to 1164.
that's talking about Clemens and
Right.
the Supreme Court's decision and all, but where are we talking about the statutory provision at issue?
Yeah, so if you look at, so it's not discussing this statutory language precisely. My point is that the discussion of Mount Clemens is exactly what the statutory language is. So it bridges 1163 to 1164. And then it says that the court requires their employee maintains their separate burden of proving work performed. A complainant must still prove he or she, in fact, was an employee who performed work without appropriate compensation. And then it incorporates this damages burden shift, but we haven't even gotten to the point where we have.
I mean, do we even cite the provision that we're directly focused on now? Or is it again all that you think that the provision at issue here has the same language as what was on the discussion about Clemens, and therefore whatever analysis we had there should be transported into the provision at issue here?
Yes, consistent with, legislatures are presumed to have adopted background principles of the law. I think that's the right way to read the burden shifting statute, exactly as the court described here. That is the point I'm trying to convey.
And you would characterize the antecedent obligation, you think, is not in the text of the statute explicitly, but instead you would take as a gloss on the statute by through the steps of reasoning you've identified. You would describe that as a prima facie case of some damage. So the idea would be Ms. Beck had the burden before you even got into any of this burden shifting provisions, you would say, of making a prima facie case, not proving by preponderance, but making a prima facie case that it's already established that she has some work as an employee, so she's done on that part.
I think she still needs to show which activities.
So that part. Then the second part would be she would have to make a prima facie case that she wasn't fully compensated for however many hours she had.
Yes.
And you think she didn't make a prima facie case of Latin, leave aside whether she carried the burden by preponderance. You think she didn't have a prima facie case that she had some uncompensated employee hours?
So there are two separate, I disaggregate two things. So one, we have the bona fide dispute legal issue. We'll talk about
Separate
that,
topic.
but that one is in there. And then the second is, yes, how is she needs to show that she had employee activities.
She needs to make a prima facie case that.
Yep, that she had employee activities and she did not receive, or did not receive appropriate compensation. That would be what Bongum suggests. he needs to prove at least the fact of damage, which is consistent with showing damages in any civil
And
case.
did Bonham use the prima facie language of prima facie case? Or is that your kind of effort to take what Bonham said in the setting it said it and fit it into the statutory structure we have here? I just don't recall, so I'm not.
It doesn't even use that language. That's just the case. If he proves that he has in fact performed work for which he was improperly
Which seems
compensated.
to say the burden, it was actually the burden, in the
Yeah.
setting that Bonham was talking about it, it was actually setting a complete burden on the employee there.
Yep, and it says a complainant must still prove he or she in fact was an employee who performed work without appropriate compensation.
And so if we took Bonham literally and carried it over into this statute, it would end up being pretty strange because it would say before the burden shifting provision could apply, the employee has to show, prove by a preponderance that there was employee activity and that there was at least some of it uncompensated.
Just
You
an
have to-
hour,
you have to
5
show-
minutes.
You have to show that as
Yes.
proven by a preponderance.
Yes, I think that's the right way to read what Bonham is saying.
Seems like a very strange structure to create.
And some of it is the facts of this case are unique and the law was,
Not, perhaps not so unique, right? I mean, it is unusual in the cases that we've seen to date, but that doesn't really speak to what the universe of cases are out in the world. Ms. Hogarth, you are over your time, so if you want to make one more point very quickly, or I can let you sit down and you can get back up on rebuttal and make another argument.
Sure. I also just wanted to state quickly that we also have the bona fide dispute statutory language that I think is also critical here that the ALJ just did not engage with, but I think also counsels in favor of the arguments that we've made in our brief.
Thank you.
May it please the court, excuse me, Jason Engel on behalf of respondent Lisa Beck. This is a case where Ms. Beck has been trying to get paid for wages that she worked for 8 years. The lawsuit's been going on for 5 years. The issue is clear on the last remand that the issue is to give a quantitative figure for damages, give a quantitative approximation. The ALJ followed this court's instructions to a T. This court also found no fault with any of the findings of fact. There's two bases, in addition to the one that was talked at length with petitioner's counsel, there's really two bases why the burden of proof falls in favors the respondent here. One is that there's the exception in the OAH rules 2822-.2D, which says the party asserting an exception into the requirements or prohibitions of any statute or rule shall have the burden of producing sufficient evidence to establish that exception. Clearly, an exception to the rule of here is that independent contractor, and that's what they're arguing.
I guess I find that less clear. I mean, which you could say that the employee is an exception to the independent contract rule. I just am not quite sure what the rule is or the exception if you're using those two concepts. I mean, I would think more you would look to a statute and say the statute creates a rule and someone is trying to get an exception under it. So if you're relying on this exception idea, what regulation or statute are you, I mean, saying your opponent is trying to get an exception to? I think your opponent is in largest terms saying there is a statute that imposes penalties for failure to pay employees for certain, the hours they work. We're disputing how big that number, those two numbers are, how many hours, how much payment. Those aren't exceptions. Those are questions about what's inside or what's outside the statutory provision that is at issue, and really that the OAH provision in isolation would put the burden more naturally on you. So I'm not quite sure I follow the exception.
Your Honor, well, I agree that there's no specific statute. There's the rule, but there's case law that supports my argument.
The rule, what rule are you?
The rule, OAH rule.
Oh, you mean the OAH rule, right? I understand.
Right, and I think that's clear in its face.
No, but what I mean is, how would, if you were going to say somewhere there is created a requirement and my opponent, YELEEN here, is trying to get an exception from that requirement, what's the requirement that you think that was created that YELEEN is trying to get an exception from?
So the general rule is that there has to be, you have to show that you are an employee, which already has been established by this court, who performed work.
Well, I mean, it hasn't, I mean, it's been established, that's your friend on the other side's argument. It's been established that there were two hats. And then now the argument is we're in the world where we have to figure out which hat applies at a particular time. So I don't think the fact that Ms. Beck was at times an employee answers the question on the burden with respect to which hours she was an employee and which hours she was an independent contractor.
Well, Your Honor, I would disagree. And I think what the standard is, and it's really focusing on both burdens that I mentioned in my brief. And one, I think I respectfully submit that it's been ruled that she was an employee, also an independent contractor during the pendency of her time with YELEEN, at least for the period of time that's in dispute here. And it's also clear that she performed work for the employer, and it's clear that she wasn't compensated or timely compensated. It's undeniable that it was untimely. I mean, she had to be paid within 7 days. I mean, and the first payment that could arguably be considered a payment was 3 years after it in 2021. So it's clear that that was untimely. And then, so it's clear that she met any initial burden she had. And then YELEEN says, hey, for the statute, hey, we don't have to pay you as an employee because we're saying you're an independent contractor. Okay, OAH rules say if that's an exception to the statute, which it is, then the burden shifts to you.
Why is that an exception? That's where you lose me. Why is it an
Because-
exception to the statute rather than an argument that Ms. Beck hadn't shown she fell within the scope of the statute?
Because, well, a case on project support services 99A3D 243 supports that position. It was undisputed that the employer paid the employee for services, and the petitioners, the employer bore the burden of establishing that he was an independent contractor rather than an employee. That was not discussing damages. That was just generally discussing, hey, you're saying it's an exception that they proved.
And was that applying? I'm just looking back to case one right now, but off the top of my head, I don't recall. I think I may have been on that case, but I don't recall whether that burden shifting conclusion rested on the OAH rule, or instead, which is your argument that you've been making right now, or instead rested on the statutory provision that we were previously discussing.
I have to look, and I'd have to look and see what if they specifically reference the OAH rule, but it clearly establishes that this is a burden shifting.
Oh yeah, we do make reference to the OAH rule. At least I found that. But
Okay.
Do you want to talk about the statute?
Yes, with regard to the statute, I think it's clear that it applies here. It's undisputed. The ALJ made a finding of fact that there was no independent records from the employer. So they failed to keep the records of the hours worked. And Ms. Beck provided.
We're looking at E4.
Correct, Your Honor.
Okay.
And Ms. Beck provided evidence to show just and reasonable inference of the amount of work done and the extent of work done. So the only way that petitioners.
Can I ask you, like, B also requires, as it relates to, there are two issues kicking around. One is how many hours she worked as an employee, and the other is how much compensation she got as an employee timely, I guess, because
Right.
if it's untimely, it may decrease the ultimate amount of liability, but it still is a source of damages,
Correct.
treble damages sense. But because it goes on to say, 4B goes on to say the extent of the work done or what compensation is due for the work done. And so you would say she, as a matter of just and reasonable inference, also showed that, at least if you're talking about timely compensation, she didn't get timely compensation for, in your view, all of whatever work she did as an employee. None of it was timely compensated, and all of it is therefore a source of some kind of damages.
Yeah, with regard to the time in dispute in this lawsuit, for certain, Your Honor.
And did you, the ALJ was very explicit that the burden of proof was on SHEA YELEEN, had been shifted by these provisions to SHEA YELEEN relative to the number of hours worked. I at least had a hard time seeing where the ALJ was explicit about who bore the burden of proof with respect to the allocation of payments to, because some money was paid. Now, maybe none of it was timely. It's subject to the, conceded, the defense about conceded payments, but do you think do you think the ALJ somewhere was very explicit that it was also placing the burden of proof on SHEA YELEEN with respect to which payments should be attributed to employee work and which payments should be attributed to general independent contractor work?
I think he was explicit that the burden shift whenever the employer contended that Ms. Beck was an independent contractor. If your question is throughout his analysis, if he applied that, my answer would be no. For instance, when there is invoices that that show for time for work paid, but they don't indicate, it doesn't say social media, for instance, or it doesn't say something that's clearly employee, I would argue, Your Honor, that the burden is shifted to the employer to establish, hey, this is an exception to the statute. I'm saying you're not an employee. You're wearing, in this dual role, in this task, you're wearing your independent contractor hat. And here's the evidence I have to support that defense to avoid payment of an employee.
But just to be clear, you didn't file any kind of cross petition, so you're not trying. I know you make some arguments that the ALJ made some mistakes that favored SHEA YELEEN, but you're not seeking any sort of affirmative relief. You would just be using those as ways of saying that any error the other way was harmless or something.
Right.
Is that correct?
That's correct, with a little bit of a caveat, meaning that I didn't file a cross petition 100% correct. And but to the extent the court has the evidence before it and you believe that the substantial evidence supports, based on your analysis of the burden shifting and before you, if you thought that the damages should be higher, that you'd have that before you and you'd have that ability. But I did not.
We wouldn't really, because the other side wouldn't have had an opportunity to respond to that because you didn't file a cross petition. Can you, I just make sure that we get an answer to Judge McLeese's question. He was asking about the burden of proof and where it lies when we're trying to figure out where money that was paid, where it was allocated, right? So if, say $3,000 was given to your client, how do we figure out, was that actually for employee services or independent contractor services? And do you think that the burden of proof is on SHEA for that as well? Do you think the ALJ clearly stated that? Is it implicit in the ALJ's order? Can you speak to that specific issue, which is what I think Judge McLeese is raising?
I think both burdens of proof arguments I made in my brief support the fact that when allocating damages, the burden was on SHEA YELEEN to say, hey, this falls outside the scope of employee work. This is when Ms. Beck was wearing her independent contractor hat.
So when we gave her $3,000, I'm making up the number,
right?
Because I don't remember the exact, but when we gave her $3,000, we were paying her for employee services, and so you should discount that from any damage award that we that you give Ms. Beck. So,
wait, sorry, can you repeat that again? I'm not quite following.
As far as, some money was paid, right? But I think that there is a factual question of what was that money for? Was it for employee services or independent contractor services? And where does the burden lie on that? Do you think the ALJ addressed that question specifically?
I don't think he addressed it specifically, Your Honor.
So where does it lie?
I think it lies whenever there's, I think it lies that whenever the petitioners are claiming that it's not employee wages, the burden is on them, because the burden of proof in the two-part burden, the burden that petitioners talked with Your Honors about, and B, the OAH rule that I talked about, and C, case on project, also supports that, Your Honor.
But I mean, okay, we're talking about two different things, and I think YELEEN's position at that point would not be that it was independent contractor payment. It would be that it was employee payment, because they're seeking to, I mean, in their view, they would be responding to Ms. Beck's complaint, and their position would be that they were mitigating the damages by at that point paying for, I guess, potentially conceded employee hours.
Right.
And so how do we figure out? I mean,
I mean, I think what this court said before was that in that approach, the way that you address that is you can do quantitative analysis on the variety of ways that this court provided, and the ALJ considered a wide variety that both sides provided, and ultimately came with his own determination that 59.6% was the appropriate way based on his manner of calculation. So I think that tracks what this court said and endorses what this court said. So I think that's not anything that's abuse of discretion or improper use of application of the law in the way that the ALJ determined both, the amount of damages or the amount, how to apply a credit with regard to what was paid. I think the other thing with the burden of proof issue that I haven't really touched about either is, I think the arguments that respondent is making is consistent with the liberal interpretation of the statute and the remedial nature of the statute. Otherwise you're heaping a lot of burden on someone, particularly in a situation here where it is, the employee is supposed to keep records. The employee didn't keep records. There's a record keeping provision that the employee was supposed to keep records for 3 years. The petitioners failed to adhere to that. That's 32-1008. So I think the liberal interpretation of the statute also supports it. Also, I think Bongham actually supports the position of the burden shifting. And I want to point your honors to one provision or one portion of Bongham where it says, quote, when the employer has kept, and this is what page? 1163 of that decision. When the employer has kept proper and accurate records, the district acting on behalf of the employees may easily discharge its burden by securing the production of those records. And then cites Clements. It says, however, if the employer fails to discharge its burden of producing accurate or adequate records, the court must calculate an award of damages, even if only an approximation. So I think that suggests that it is the employer's burden to produce the records, accurate or adequate records. So I think that supports it as well. Turning to there's 3 methods that plaintiffs, petitioners rely upon to try and contend that it was abuse of discretion. I think all 3 are flawed. I think as an initial matter before we get.
Mr. Engel, you're now over your time, and
Okay.
I think you're going beyond the argument that we heard from YELEEN. So if you want to wrap up your argument and.
Sure. May I address I would just refer to I would like to address the bona fide dispute argument, if I can.
Just briefly, but.
Okay, briefly. So there's 3 main issues here. There's waiver, because it was never raised previously. There's no reason why, if they thought it was a viable defense, which it's not, that they should have raised it during the trial, during their closing arguments, during the first appeal. They were silent. They never did it. So it's a waiver, and they can't argue it now in the second appeal, and there's case law to support that. But beyond that, there was no written notice. I think the Rothberg decision touches upon this, that it says, they go through the fact that there was a final paycheck, and they go through the analysis and say that wouldn't be sufficient, because it doesn't make sense with the rule, and it would make some of the language in the statute superfluous. So that's not sufficient. And then there's also the timeliness. The payments weren't timely. They had to be paid within 7 days or the next time she was supposed to get paid, whatever's earlier, and that clearly didn't fall within that. And the $2,500 check, I mean, that was never even received. It was returned. And the written notice, first of all, it would have been late. And then second of all, the written notice that was provided didn't talk about anything related to conceded wages. So, and the only one very brief point is so that with regards to allocation of prior payments, I just think the documents referred to in respondent's brief show conclusively that the various things they're claiming were, a lot of them were already considered and not included in respondent's claim for damages. Thank you, Your Honors.
Thank you, Mr. Engel.
I'd like to jump right into the bona fide dispute question. I just want to make it very clear what this statute actually prohibits, and it is a timing requirement subject to bona fide disputes. And when you try to apply that onto the facts of this case, I think it fits quite naturally because no one disputes employers can have an employee keep track of their time. Then the question becomes, what do you do when the employee isn't keeping track of their time appropriately in accordance with the employer's practices? And the statute carves out, if there's a bona fide dispute about the amount of the employee's wages, the employer doesn't have to pay and liability ends. And I think that fits this case.
That's assuming the requirements are met of
Yeah.
1304, one of which is timeliness.
Yes, yes.
So how would that work out in your case?
So if you go back through, Ms. Beck would submit invoices, YELEEN would respond immediately. So A 1396, for example, a tranche of invoices came in March. Ms. Wright responded.
But the timeliness 1304 requires that the conceded amount paid has to be paid within the time limits of 1302 and 1303. And that 1302 doesn't have anything to do with when you've asked your employee to submit invoices and then you can wait and pay once your employee submits invoices. That isn't the timeliness scheme that is created in 1302 and 1303. It requires that you pay wages earned by your employees on regular pay dates designated in advance by the employer at least twice during each calendar month. And so again, it's an unfortunate situation if your client believed in good faith that your client had an independent contractor, but and therefore wasn't doing the things that the statute was contemplating for employees. But I'm not quite sure how you could fit under the timeliness provisions that are incorporated into 1304 by 13 or into 1304 and that exist in 1302. If these payments don't fit within this time scheme, even though I can understand why it happened the way that it did, but I'm not quite sure how you fit under these provisions.
Yeah, so I think the answer is written notice went basically immediately. Large tranches of invoice would come in, Ms. Wright would respond.
I understand all that. Let's go to 1302 and so 1304 says
Mhm.
to qualify, you have to have made your conceded payment within the time frame contemplated by 1302.
Yes.
You're with me so far?
Yes,
So then the question is, 1302 says you got to pay your employees at least twice during each month.
yes,
And if your conceded payments are instead a lot later than that because you had a whole different scheme that wasn't paying them twice every calendar month, but instead was employees submit invoices and then I will respond promptly to your invoices. I mean, that may be what happened, but I don't see how if you promptly, again, imagine a situation where someone is an employee and their arrangement is employee is going to submit invoices and once the employer will pay the employee. Once the invoice is submitted, the employer will pay within 2 weeks. That's the arrangement ahead of time. And then somebody later comes in, the employee later comes in and says, well, that's what I agreed to. I understood, but I didn't know there was a statute and the statute requires that I be paid sooner. I don't know how you would treat the payments that were belated as conceded payments because they weren't timely under what the statute requires. So how are your payments timely under this provision?
yeah, so 2 points. So the first is the written notice went basically immediately when the invoices would come in. And then the second,
Why is that relevant to the statutory language here, which doesn't refer to written notice?
oh, sorry, you're talking about 1302.
Yes.
Yeah, so 1304, the bona fide dispute says that you satisfy those timing requirements if you satisfy 1304. does it? So concedes within the time required by 32-1302.
Right, if you
Yeah.
pay your conceded amount within the time required by 1302. It doesn't
Yes.
say, so you have to pay your conceded amount within the time required by 1302.
Yes.
So
And-
complying with 1304 doesn't meet 1302. Succeeding under 1304 requires that you have met 1302 is what I would have thought. Are
Yeah,
you reading it differently?
And so, right, so what I'm trying to say is at A 1435 through 1440, you can see payments that were made. There were payments made during this time, March 13th, April 2nd, April 16th. So we're giving notice that there are disputes and paying some amounts of wages, but we have disputes over amounts of employee hours.
I'm sorry, you think that by having made a payment without any signal that it was a dispute of any kind, within 14 days of some of the employee work created meant that that was a conceded amount that meant all other payments would be delayed, no matter how long they were delayed?
Well, I think that's what the WPCL contemplates, is that this is about like deliberately stealing wages are owed. And the whole problem was that we would give notice that the records were not adequate to ascertain amounts and would respond as soon as invoices came in. That's the submission I'm trying to make. The second point is that the ALJ's conception is that the statute was triggered when she sent all her invoices on February 18th, 2019, and that we somehow needed to have paid then. That's not even a possible real way that fits within the statutory framework at all. And at that point, we again noted that we had many disputes with the invoices and we're trying to resolve it and ultimately conceded amounts.
What about the waiver argument?
Yeah, so that's not the ground that the ALJ gave. And I think the second point is that when the dispute was principally over employee independent contractor, the 1304 doesn't make as much sense.
So
Because
because the ALJ decided this on the merits on remand?
Yes,
Would
yes.
you get a pass on not having raised it before?
Well, the ALJ's decision has to be upheld for the reasons the ALJ gave, and the ALJ did not think it was waived and addressed it on the merits. The second part is I think the legal framework matters substantially for ascertaining the right measure of damages. And then the third is that the court's decision that certain activities where employees made this very relevant because the bona fide dispute talks about amounts of wages. And when you're in a world where we think there are none because you're an independent contractor, it just doesn't fit the same way. And so that is why we submit that it has become especially relevant following this court's last decision. If the court has nothing further, I will rest in my briefs.
Thank you, Ms. Hogarth. Thanks to both counsel. We appreciate your arguments today and the case will be submitted.